This is a true crime discussions channel. We speculate. This is all just speculation. Because it's true crime, it's for mature audiences only. There will be no children allowed, no exceptions. Everything on this channel falls under fair use. Please remember to like, comment, subscribe, and share. It's free.
Hey y'all, it's so good to see you. Kimmy C123 gifted 2 memberships. It sounded like a mouse was running in my headphones. That was weird. Those went to Jacqueline H. and Bruce Banner. If you are Jacqueline or Bruce, please tell Kimmy C123 thank you for the membership. And thank you, Kimmy. That was so very sweet and supportive of you. I really appreciate that. I'm going to grab the crazy train and pick y'all up on the way to Speculation Station. I'm going off the rails on a crazy train. It's so good to see y'all. Let me shout y'all out. Hello, Brittany, Allie X, Bad Girl, Michael Green Chili Enchilada, Rhonda Loves, Hannah UK, Southern Cats, Teresa, Clay, Bazard, LJ, Bellis, AM, Jim Corby, Bad Girl, Rhonda, I know I said some of y'all twice, Scratch to Paint, Cracker Jacks, Megan J, Kimmy C123, Lisa Lynn, Hannah UK, Nene Nuts, Jill Corby, if I haven't said you, Indy, it's good to see you. And anybody else, if I missed you, let me know and I'll shout you out. Megan J, Bellis, my love. So hard to see you. Boomer, Megan Crowley, Smoky Mountain Mermaid, Donna Barkley, Cindy from sunny South Florida. It is good to see y'all. Okay. So what we're going to do today is we're going to go through these documents and talk about what his defense team is saying and then what the district attorney is saying in response. First, I wanted to play this video from Fawny. Here, she wanted us to play this on the scammer stream to kind of have a laugh for a minute, and I thought it was very sweet. It just wasn't the time during that stream, so we will watch this and have a quick laugh. This is Singer Sew and Stow large sewing box unboxing and review. She's gonna open that sewing box. Oh, ain't it cute? Ain't it cute?
So isn't it cute?
It's got little hearts on it. That's so cute. I got a sewing box like that. Hey, Ava Slim. M Show, good to see you. She shut that thing. What is in there? Big old monster gonna jump out and grab you. Shake you. She said, what the Sam hell is going on here?
What?
What's in there? It's got pretzels. Oh my goodness. Basil would love that. It's full of cookies. Oh, that's them cookies that are in that tin. Boy, Basil would love that. That was cute. Thank you for sharing that, Bonnie. Let me go to my channel. That was so sweet, Bonnie. Thank you for sharing that. Hey, Becky and Ryan. Yeah, it had cookies. That's something you could get for your mom's Mother's Day. I bet she would like it. All right, so we're going to talk about these documents that basically what I want to go through is what the defense filed and then what the district attorney said in response. So this is going to be basically a document read, bunch of documents today. Hey, Manda. Wasn't that sweet? I thought that was cute. Manda, good to see you. Okay, so we're going to play, this is going to be a document read. We're basically going to listen to, we're going to go through each document. We're going to listen to what the defense said first.
State of Florida is a... Hey, y'all, I've got some documents to go through here with y'all.
and then we're going to listen to the district attorney's response to each document individually and share our thoughts, opinions, and speculations on that. Now, these documents are being looked at by the judge right now that we saw in court yesterday, and he's going to make a decision on that. Hey, Bogart. And then we're going to know what the decision was.
On whether...
This is the district attorney again. Hold on. That's what we need. Oh, this one does have music behind it, so I do apologize about that. So we're going to listen to what his team said, and then we're going to listen to what the district attorney said in response. So, with that, we will get started.
6-page document, a 22-page document, and this first document is 14 pages. So I'm going to go ahead and get started. This first document is obviously the state of Florida as a plaintiff versus Stephen Michael Stearns, the defendant. It is a motion to suppress evidence obtained from unlawful seizure of cell phone. It reads, comes now the defendant, Stephen Michael Stearns, by and through his undersigned counsel, pursuant to the 4th Amendment to the United States Constitution, Article 1, Section 12 of the Florida Constitution.
No, I did not see that. Scratch the paint. Peaches and her beautiful baby. I have not seen that. You'll have to inform me as to what that is. Hey, Allie X and Veronica and everybody just coming in. It's good to see you. Cara, good to see you. Good to see you.
And the Florida Rule of Criminal Procedure 3.190 subsection G, and hereby moves this honorable court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful seizure of his cell phone. As grounds for this motion, the defendant states, Introduction. This case presents a flagrant violation of Mr. Stearns' constitutional rights under the 4th Amendment, Article 1, Section 12 of the Florida Constitution.
Oh!
Detective Tangler with Orange County Sheriff's Office ultimately...
Oh! That Peaches. They identified her. Peaches from the Long Island serial killer case. Peaches was an individual that was found with the other victims of alleged Long Island serial killer Rex Heuermann, and she was called Peaches because she had a tattoo of peaches on her body, and that was the only way that she was identified. There was also a toddler, a baby. I think it's been a minute since I've looked, but I think the child was 2 to 3 years old. And this baby was also a victim of allegedly a victim of Rex Heuermann, and they found out that the baby was related to the woman with the peaches tattoo. So we called her Peaches. Everybody did. So Peaches and her baby went unidentified for a long time. Hold on. Now we're going to have to pause this for a second because I got to find out. I got to look this up because I follow that case too. I'm going to pull it up in just a second. Yep. Look at her babe. Goodness gracious. Look how cute. All right, let's see what they say. Oops. Okay, so Gilgo Beach. I'd like to close out of this. I cannot. Gilgo Beach victim known as Peaches to be identified, says sources. This was 1 day ago. That was how she would. This victim of Rex Heuermann allegedly was identified by this Peaches tattoo, and it looks like a little heart, and it's a little peach with a bite taken out of it. So what to know? A massive wildfire in Ocean County, New Jersey has burned thousands of acres, forced thousands of evacuations, and closed several roads. The fire began shortly before 12:30 p.m. on Tuesday, April 22nd at the Greenwood Forest Wildlife Management Area in Barnett Township, Ocean County. I mean, I don't understand what the relation is. Let's play this. No. Okay, I would like to hear
Skip
this.
this ad. The same way you skip the drama of
Hold
screening
on a
for
minute.
colon cancer with a Cologuard test. Come on.
Expert took the stand to answer questions. Island DNA testing was the focus again in the case.
Okay, I'm going to start this from the beginning. This is from NBC New York about Gilgo Beach trial accused serial killer returns to court for DNA hearing.
Also on Long Island, DNA testing was the focus again in the case against accused Gilgo Beach serial killer Rex Heuermann. An expert took the stand to answer questions about its accuracy and reliability. And a judge will decide if it can be used as evidence in the trial. News 4's Pezzi Chang is following it.
A showdown in court today as both sides argued over whether or not DNA evidence can and should be admitted in this murder trial. Rex Heuermann's attorney, Michael Brown, challenging the prosecution's first witness, a professor who said this genetic testing is accurate.
Does she have the background, the qualifications, the know-how, the experience, the expertise to talk about a forensic application of this DNA?
Prosecutors defended the genetic testing that has linked hairs found at 6 of the 7 crime scenes to Rex Heuermann and members of his family. Brown called it magic.
They want to, in essence, have...
Hold on. The family member hairs.
The jury.
I just want to say, like, a lot of people have had questions about the hairs from Rex Heuermann's family members. I do believe that's just from, like, basically doing laundry together and things like that. Hey, Anders, good to see you. Yeah, we're going to jump right back into that. I just hadn't seen this yet. I wanted to look at it with y'all.
Rely on this, which is not trustworthy, it's not reliable, it's not scientific, and it shouldn't be utilized in a court.
Heuermann's lawyers argue this method of DNA testing has not been admitted in a New York court before and is substandard. Watching today's hearing, Heuermann's ex-wife, Asa Ellerup. The couple finalized their divorce, but Asa's still in court alongside her daughter.
She's interested to learn about the DNA process. Obviously, one of her hairs and one of her daughter Victoria's hairs were some of the evidence that were found on some of the victims.
The trial resumes next Wednesday when the prosecution is expected to introduce more witnesses. It could take weeks for the judge to make a decision on whether or not this DNA evidence is admissible. In Riverhead, Pezzi Chang, News 4, New York.
I'm going to look into that. I'm going to try to keep up with that, too. Let me take us back to Peaches, because I thought that might tell us. She's identified as a U.S. veteran. Gilgo Beach victim Peaches identified from key clue on her corpse in bombshell case update. Okay, nearly 3 decades after their remains were discovered along a stretch of Long Island shoreline, 2 of the Gilgo Beach victims, once known as Peaches and her toddler baby doe, have finally been identified. In a dramatic press conference Wednesday, Nassau County officials revealed the victims as Tanya Denise Jackson, who is 26, and her 2-year-old daughter, Tatiana Marie Dykes, bringing long-awaited names and humanity to a case that has haunted investigators since 1997. Jackson, a single mother and U.S. Army veteran originally from Alabama, was living in Brooklyn at the time of her murder. Her killing, along with that of her young daughter, had remained a heartbreaking mystery until now. It was reported by the Daily Mail that her daughter was born in Texas. During the press conference, officials said that while the victims have long been linked to the Gilgo Beach serial killer case due to the location of the remains, they, quote, are not discontinuing that the murders could be unrelated, unquote. Quote, today is a bittersweet day, unquote, the Nassau officials said during the conference. Quote, today, after decades, we are finally going to be able to tell you the identities of 2 victims back from 1997, unquote. They said the mother's name was Tanya, the baby's name was Tatiana. District Attorney Ann Donnelly said when asked by reporters attending the conference how long investigators had known the identities, Nassau County commanding officer of the homicide squad, Mr. Fitzpatrick, told the outlet that we had it for a while and have been catching up on 27 years of investigation. Both officials added they will continue to work closely with local and federal law enforcement agencies, including Suffolk County, the jurisdiction leading to the Gilgo Beach case. It had been previously reported that the dismembered torso of Jackson had been discovered by a hiker inside a black plastic bag inside a Rubbermaid container on June 28, 1997. At the time, it was alleged she had been killed 3 days prior to discovery. The police also noted that the torso had a distinctive heart-shaped tattoo of a peach on her left breast, which earned her the name Peach's nickname. Inside the container was also a floral patterned pillowcase and a red towel. In 2011, 14 years after the initial discovery of the torso, more of Jackson's body parts were found in Jones Beach State Park. During the search for victims in the Gilgo Beach investigation, it was reported that her skull was never found. Also in 2011, the remains of a young girl were also found in the same area along Ocean Parkway. DNA tests revealed that baby Doe had been Jackson's daughter. Similar gold jewelry was found with both victims' remains. The identity of the bodies eluded local police and the FBI, who sought out the public's help to find out who they were. And that's that. Thank you guys for telling me. I do really appreciate that, because I've been following that case for a little while too, although I haven't done a lot on it. And we'll get back into the documents from Stefan's attorney and the documents that the DA filed in response. I'm so happy they found the names too, and now Tanya and Tatiana can rest easily. You're calling it from sleep deprivation, but you're crying now. Oh. All right, so we're going to get back into these documents. All right, so first we're going to listen to what the state said as far as unlawful seizure of the cell phone, and then we'll listen to and discuss what the, scratch that. We're going to listen to what the defense said as far as the unlawful seizure of the cell phone. And then after this, we will listen to what the state said in response. I will drop the link if anybody wants to come up and talk about it. Cell phone. It reads, comes now the defendant, Stephen Michael Stearns, by and through his undersigned counsel, pursuant to the Fourth Amendment to the United States Constitution, Article 1, Section 12 of the Florida Constitution, and the Florida Rule of Criminal Procedure 3.190, subsection G, and hereby moves this honorable court to suppress all evidence obtained directly and indirectly from law enforcement's unlawful seizure of his cell phone. As grounds for this motion, the defendant states, Introduction. This case presents a flagrant violation of Mr. Stearns' constitutional rights under the Fourth Amendment, Article 1, Section 12 of the Florida Constitution. Detective Tangler with Orange County Sheriff's Office ultimately seized Mr. Stearns' cell phone without consent, without a warrant, and without exigent circumstances. The phone was then retained for over 9.5 hours before law enforcement coerced a purported, quote, consent, unquote, for its forensic examination. Because the seizure was unlawful and all evidence obtained bears the taint of this initial illegality, the court should suppress the cell phone evidence and all derivative fruits. This motion is filed contemporaneously with related motions to suppress evidence obtained from the unlawful search of Mr. Stearns' phone and evidence obtained through the subsequent Google account warrant that relied on the fruits of this unconstitutional seizure. Evidence to be suppressed. Any and all tangible evidence obtained contemporaneous to and following the illegal seizure of Stephen Michael Stearns' cell phone, specifically including but not limited to all data obtained from the subsequent download of the phone, all evidence obtained through execution of the Google warrant, and all derivative evidence and investigative leads developed through exploitation of these constitutional violations. Oh, good. I bumped my mic and I was apologizing and it was muted. Okay. So that's saying that basically because the way they obtained the cell phone, they seized it illegally, that everything should be thrown out. Everything obtained from his phone, all the pictures and videos of Madeline, everything they got from the Google account, everything at all whatsoever having to do with Madeline. I'm going to say this is not what happened, but let's say, for example, if they had found Madeline's body because for some reason he put in Google Maps, let's say that he wanted to go to a specific location, right? And that was where they found Madeline's body. Basically, they're saying that even like if that had happened, that even that would have to be thrown out, and they would have to prove that they found Madeline's body a different way, because everything from the cell phone would have to be thrown out. Now, that's not what happened as far as that goes, but the whole CSAM trial for Madeline and the images and videos and proof of everything he was doing to her for years came from that phone. So again, if this was to pass, if the judge grants this motion, I mean, all evidence from the CSAM trial, they would have to say they got it another way. And considering the fact that it's on the Google account and on the phone, how are you going to say that you obtained that other than through his phone and through his Google account? Like, there's no other way to obtain that. So all that evidence would be null and void.
Standing. Stephen Michael Stearns has standing under the Fourth Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution, as he was the owner and possessor of the cell phone that was illegally seized on February 27th through 28th, 2024. Riley versus California establishes that cell phones are entitled to heightened Fourth Amendment protection due to the vast amount of private information they contain. They cite Riley versus California from 2014. Burden on the moving party. The moving party's initial burden has been met through documented evidence of a warrantless seizure in law enforcement reports. Once established that a seizure occurred without a warrant, the burden shifts to the state to prove an exception applies. They cite Norman versus State from 1980.
So they do have the other drive that does have pictures and images of other children, okay? But Stephen is not the perpetrator in those images and pictures. All of the pictures and videos where Stephen is the perpetrator are on his phone and on his Google account. Yes, he has child pornography that show horrific things happening to children, but other people are doing those horrific things. So therefore, he could get in trouble for having it, but but he would not have the same charge as he does for Madeline, and Madeline would not get justice in that aspect. And he would also not be looking at the death penalty. So yeah, he could definitely get charged for having CSAM on that USB drive, but he's not the perpetrator in those videos. So that's an issue. I don't think and praying the judge will allow the suppression. I don't either, but I thought they had a good argument, and we'll listen to their argument. I'll try to go through and figure out where they're arguing on all of these things and listen to their arguments after we listen to the documents. But the judge said yesterday there's no case law on this. So his ruling is probably going to make case law, at least in the state of Florida. And so he's got that's a big thing. So he's going to be weighing this out, and it's going to boil down to the evidence and what each side can prove. It's a big thing to have a case become case law, and the judge has to make sure that they double check, like, you have to be very much on point about your decision and what each side is arguing, and make sure that you go 100% by the book, because it could be what's referenced in later cases. When he said that yesterday, there is no case law about this, so I'm going to need to hear oral arguments. That made my heart drop, because he's going to have to be very much stern and by the book. So it's going to boil down to who's got the best argument.
While I flip this page, if you guys want to see us talking about these documents and basically stating what we thought about it, you can do so in the live stream with this thumbnail. Statement of facts.
Yep.
1. On February 26, 2024, at approximately 2000 hours, Jennifer Soto reported her 13-year-old daughter, Madeline Soto, missing to the Orange County Sheriff's Office. 2. On February 27th, Detective Francis Hunt identified inconsistencies in statements provided by Ms. Soto and Mr. Stearns. 3. Detective Tangler of the Orange County Sheriff's Office was assigned as lead investigator. 4. On February 27th, 2024, at approximately 1600 hours, Detective Tangler, accompanied by Detective Acosta, contacted Mr. Stearns at his residence. 5. The detective's interactions with Mr. Stearns were audio recorded and captured the exchanges between law enforcement and Mr. Stearns.
Veronica said Strategic Eye said that no matter what, he will be pursued for CSAM by the phone or PC or hard drive or whatever. He will not get away with it no matter what. So I feel much better and confident now. Yeah, he could still be pursued for the USB drive that has child pornography on it, but that will really break my heart because he's not the perpetrator in those images. Therefore, it's a much lesser charge, and Madeline will not receive justice for the hell she endured for years. And considering that he's looking at a murder charge and they haven't brought that up, I mean, yeah, they could pursue him for the USB drive, but I would question if they would even do it because he's not the perpetrator. I'd have to look up how many cases have been pursued specifically for having that on your computer or a USB drive, as opposed to people who were actually perpetrators and doing this to a victim. How many times people have got in trouble, like what are the statistics and ratios on it, what the charges were, what they stick, like how they stuck, like, you know, a misdemeanor versus a felony, 6 months versus 12 years, things like that. And it's state by state. It would take probably a whole live to try to figure that out.
6. Mr. Stearns' residence is located at the address. 7. Detective Tangler sought limited access to Mr. Stearns' cell phone, specifically requesting only to check his Google login status by asking, quote, "Is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google," unquote. 8. Mr. Stearns responded, quote, "Yeah," unquote, to this specific and limited request. 9. After exceeding the scope of this limited consent, Detective Tangler unilaterally announced, quote, "I'm going to hold on to your phone," unquote, and quote, "I'll give it back to you when we're done," unquote. 10. Mr. Stearns expressed explicit concern about maintaining contact with his father through that phone. 11. Detective Tangler dismissed Mr. Stearns' concerns by stating they could call Miss Soto's phone instead. 12. Mr. Stearns was given no choice regarding the seizure of his phone. 13. No consent was sought for the seizure of the phone. 14. Law enforcement made no attempt to obtain a search warrant for the phone despite having ample time to do so. 15. The detectives did not present Mr. Stearns with a written consent form for the seizure. 16. The detectives did not advise Mr. Stearns of his right to refuse consent. 17. The detectives did not provide Mr. Stearns with any documentation regarding the seizure of his phone. 18. The detectives did not document any extingent circumstances justifying the warrantless seizure. 19. On February 28, 2024, at approximately 1:30, detectives again contacted Mr. Stearns.
Now, this is just going through the events of the seizure of the cell phone. That's the document we're looking at. Veronica said, "I was very sad and furious yesterday, but now I'm confident again. Whatever happens, Maddie deserves our good vibes and our hopes to get her justice. She needs us to be strong like she was." And I'm going to say absolutely 100%. I'm going to try this new thing and see if we can use it.
Boom, 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 bam.
We'll see if I get in trouble, but yes, exactly, 100%. We absolutely got to be strong and keep praying for her to get justice, because this whole situation is just every level of effed up.
20. The second contact occurred approximately 9 hours and 30 minutes after initial seizure of his phone. 21. During this midnight contact, detectives referenced their earlier unauthorized seizure, stating, quote, "I told you that I was going to hold on to it and that we would like to download your phone, right?" unquote. 22. The detectives presented Mr. Stearns with an ultimatum, quote, "Is this something I have your consent to do, or do I need to get a search warrant for your phone?" unquote. 23. At the time of this midnight interaction, Mr. Stearns had been detained outside in 50 to 60 degree temperatures. 24. Mr. Stearns was wearing only flip-flops, khaki pants, and a thin hoodie. 25. Mr. Stearns had not eaten all day prior to the incident. 26. Mr. Stearns was not allowed to return to Miss Soto's vehicle, which was heated despite cold weather conditions.
Let me play the world's smallest violin for you. The song I'm going to play is "My Heart Bleeds for You."
27. Earlier that night, Mr. Stearns had taken an Ativan, a prescription medication to manage his panic attacks. 28. Mr. Stearns clarified to authorities that he had taken the tranquilizers to help him sleep, as he had been struggling with insomnia. 29. Ativan is a prescription sedative commonly used to treat anxiety and panic disorders. 30. Ativan is known to cause drowsiness and sedation and impaired alertness. 31. Mr. Stearns described the effects of Ativan to law enforcement, stating, quote, "This is why I missed your calls. I'm sorry. Took an Ativan and conked out for a few hours," unquote. 32. At approximately 2:40 on February 28, 2024, Mr. Stearns' phone was taken to the Orange County Sheriff's Office Digital Forensic Unit. Legal argument. A. The warrantless seizure of Mr. Stearns' cell phone was unconstitutional. The Fourth Amendment protects against unreasonable seizures of property, even when no search has taken place. United States versus Place from 1983 is what they state. A, quote, seizure, unquote, of property occurs when there is some meaningful interference with an individual's possessory interest in that property. They cite United States versus Jackson from 1984. The instant matter presents precisely such a meaningful interference as Detective Tangler unilaterally seized and retained Mr. Stearns' cell phone for over 9 hours without consent or probable cause. The Florida Supreme Court has consistently held that Article 1, Section 12 of the Florida Constitution is coextensive with Fourth Amendment jurisprudence. They cite
Yep, LJ.
State versus Hernandez from 1998. While law enforcement may temporarily seize property to prevent destruction of evidence while seeking a warrant, such seizures must be, quote, properly limited in scope, unquote. They cite Place. The United States Supreme Court has emphasized that courts must consider, quote, the length of the detention, unquote, in determining whether a seizure is reasonable. The Supreme Court held in Place that even when supported by reasonable suspicion, a 90-minute detention of property was unreasonable. Here, the 9.5-hour seizure, unsupported by any reasonable suspicion, grossly exceeded the temporal limits deemed reasonable in Place. The Florida Supreme Court analysis in Golphin versus State further illuminates why the seizure here was unconstitutional. Golphin versus State from 2006, what they cite. In Golphin, the court examined whether retention of identification during a brief warrants check constituted a seizure, emphasizing that, quote, not all encounters between law enforcement and individual citizens constitute seizures, unquote, but rather courts must examine the totality of circumstances to determine if there was meaningful interference with possessory interest. Unlike Golphin, where officers merely retained identification briefly during a consensual encounter, Detective Tangler effected a full seizure by unilaterally announcing that she was taking possession of the phone without seeking consent, retaining it for over 9 hours, and completely depriving Mr. Stearns of his ability to communicate with family members.
Now, this one, this case they cite, I'm going to try to, I don't know why I didn't think about it before, but I'm going to try to write down all these cases they cite, because basically in the DA's response, they reference these cases, and what we call here on these YouTube streets, they clap back. So Golphin, U.S. versus, or Golphin versus State, she's again saying that they took, okay, hold on a minute. Courts examine whether retention of identification. So they took this person's identification during a warrants check. So basically he got pulled over. He gave them his identification, and they ran it to make sure he didn't have any warrants. And they're saying retention of identification during brief warrants check constituted a seizure, emphasizing that not all encounters between law enforcement and individual citizens can constitute seizures, but rather courts must examine the totality of the circumstances. Yeah, they retained his identification briefly during a consensual encounter, is what they're saying in Golphin versus State. Like, he gave them his ID, and they kept it for some amount of time, briefly. They're saying Detective Tangler did a full seizure by unilaterally announcing, by basically saying that she was taking his phone without him saying you can take it, and she kept it for over 9 hours, depriving him of his ability to call his daddy.
The extended duration and complete deprivation of Mr. Stern's possessory interest in his phone demonstrates why this case falls squarely within Place's holding that even brief investigative detentions of property must be properly limited in scope and duration. Detective Tangler made no attempt to obtain a warrant despite the availability of an emergency duty judge system and ample time to do so during the initial seizure.
Now, this part bothered me because I've talked about, I used to unfortunately live a very different lifestyle, and I have gotten in trouble at 2, 3, 4 o'clock in the morning. When I get in trouble at 2, 3, 4 o'clock in the morning, there is a little area inside the police station, and you go in this little area, and there's usually like seats or whatever for a bunch of people to sit down if they want to, and they call a magistrate, and you have to wait sometimes 30, 45 minutes for the magistrate to come. The magistrate will get in his little area. It's just like kind of, when a judge comes out and you're in a courtroom, it's kind of like an elevated area right there. They will print out my charges. They would tell me what I'm charged with, and then I would go back to the holding cell or wherever it is. They have that in place. There's magistrates that are on call all throughout the night, all throughout the weekend, 24/7, and you're supposed to call the magistrate, go in front of that magistrate, and for the police it would be to say, I need a search warrant for this, that, and the third. And she didn't do that, and that's bothering me. I'm really concerned about that because that's what that's there for. Why didn't she utilize that? That's concerning.
Instead, Detective Tangler retained the phone for over 9.5 hours without providing any indication of when or how it would be returned, far exceeding any reasonable scope or duration under Fourth Amendment jurisprudence. The length in detention alone precludes any argument that this was a properly limited investigative detention under Place and its progeny. 1. The initial seizure exceeded the scope of any purported consent. While consent provides an exception to the Fourth Amendment's warrant requirement, such consent is strictly circumscribed by its express scope and circumstances. They cite Florida versus Gimeno from 1991. The United States Supreme Court has established that the standard for measuring scope of consent is one of objective reasonableness. Specifically, quote, what would the typical reasonable person have understood by the exchange between the officer and the suspect, unquote. This objective standard protects against law enforcement's unilateral expansion of narrowly granted permissions into broad investigative authority. Florida courts have consistently enforced strict limitations on the scope of consent, recognizing that permissions granted for one limited purpose cannot justify broader government intrusion.
So basically they're saying he gave permission for them to look at his Google Maps to see if he was logged onto his Google and look at his call history, and she's saying that limited scope of consent does not constitute you going through his whole entire phone, his Google account, his pictures, his videos, all of that. He did not give you permission to do that.
Appellate versus State, the 5th District Court of Appeal held that consent to enter a home to check on well-being did not authorize a full search of the premises. And Appellate versus State from 2015 is what they cite. Similarly, in State versus Wells, the Florida Supreme Court determined that consent to search a car trunk did not extend to closed containers within that trunk.
So, I mean, and that's true. You can't. If a cop were to pull me over and he was to ask to search my trunk and I had closed, storage containers in my trunk, he can't open those storage containers unless he gets a warrant. I don't know if it would change if, like, you could see through the lid and see, like, a bloody knife in there or something. I don't know if that would change things or not, but I know that they can't open containers, they can't open locked boxes, all of that's true, and they're citing that because it relates in the aspect of he handed you his phone to look at his Google Maps and his call history. Basically, they're comparing the Google account to a locked box in a trunk. It's a locked box on the phone. You can't go into the Google account without having a warrant to do so, is what they are saying. It's good to see you, Blue Sapphire. Sapphire said at the time they took his phone, they didn't realize the case it would become. They were only trying to find poor Maddie. That is true, and I'm wondering if that will play a case as far as extingent circumstances goes.
And they cite State versus Wells from 1989. The decisions reflect the bedrock principle that law enforcement may not exceed the reasonable scope of specifically granted consent. In this instant case, Mr. Stearns provided extremely limited consent for Detective Tangler to, quote, go in your settings real quick, unquote, solely to, quote, see if you're logged onto your Google, unquote. No reasonable person would understand this narrow permission to check a single phone setting as consent to a complete seizure and 9.5-hour retention of this device. Detective Tangler's unilateral announcement that she was, quote, going to hold onto your phone, unquote, and subsequent extended seizure far exceeded any reasonable interpretation of Mr. Stearns' limited consent.
Basically, he didn't give her consent to do anything other than go in your settings real quick to see if you're logged onto your Google.
Expansion of authority mirrors the impermissible scope extensions rejected in both Appellate and Wells. Just as consent to look in the trunk does not permit searching closed containers, permission to check a single phone setting cannot justify a prolonged seizure of the entire device. The unreasonableness of interpreting such limited consent to authorize extended seizure is particularly apparent given the Supreme Court's emphasis in place that even brief investigative detentions of personal property must be strictly limited in scope and duration. They cite place again. When Detective Tangler exceeded the bounds of consent by unilaterally seizing the phone, she needed independent constitutional justification for that expanded intrusion. No such justification existed.
I don't know if you were back there. It's so hard for me to see back here sometimes. It blends in because it's like I have boxes and then it says present or invite, and I always think it's that box. So if you were up there for a minute and I didn't see you, I'm so sorry.
You're good. Keep rolling with it, because I got a hypothesis when you get done.
Okay, well, if you know the deal. If you have something to say, just let me know and I will pause it.
Okay, go ahead.
Tom said, hopefully police agencies around the country see this and make sure these officers have proper training in such manners. I agree. I hope that they see that and see this case and the issues that are being brought up and just get a warrant. I mean, the magistrates are on call 24/7. 365 days a year. Just get a warrant.
Rendering the extended seizure unconstitutional.
Okay. Go ahead.
All right. So we, based on the timeline leading up to him trying to get this vacated, so we know he complied in giving access to the phone at the condo during the search for Maddie, right?
Right.
All right. Then after they acquired access to the phone, they give the phone back then, right?
I think once they had the phone in their hand, I think they did give it back, and then they asked for it again a few minutes later, and then they keep it except for asking him to unlock it, like put the pin in, and then she keeps it from that point on, I do believe.
Okay. Then they take it back when they call him in for the interrogation, right?
Okay, so no, the first phone that they take is his original phone, the phone that had all the stuff on it. When they took that phone, his daddy came in and gave him an iPhone of some sort for him to use while the police were looking at his phone, so his dad could still contact him and he could still do whatever. And during this time period is when he's like, he's freaking out about the Google account. Then when he's interrogated, they take the second phone as well.
Okay, so there's two phones involved here.
Mm-hmm.
Have they specified what they're trying to suppress? Because if he had that Google, right? Because if he had that Google account connected to both phones, and through the procedural process of collecting information and search efforts for Maddie, and they found all of this information, in my mind, I may be wrong, but in my mind, it would be no different than hypothetically saying, okay, I've called to report a breaking and entering of my home. And while I'm in the process of giving that report and reporting items of the door frame wasn't busted, I'm missing my TV, blah, blah, blah. And in the
Uh-huh.
process of giving that report and those descriptions of the items that are missing or damaged, another cop pulls somebody over in a vehicle and they consent to a side of the road search, and my items are in that vehicle. So would it? You follow me on that? So if
Ki-
he give consent to have access to the phone, and in having do so, giving consent, and they discovered this information, there should be no grounds for suppression of information if it was all compiled in the search efforts in the first place that led up to the discovery of a deceased child.
Yeah, I mean that's where in extingent circumstances comes into play. They could say that, see, and they're going to argue this more in the files that basically Maddie was missing and he was lying, so therefore we wanted to take his phone because he had already lied about several things, and we thought that it might lead to us finding Maddie. Lord, I need to take my Prevagen, my ADHD, and I just blanked in my mind. But they're
Maybe you need to
also
share with me because I'm having this moment.
but they also at the same time are saying again that his Google account, like he gave a limited permission to look at specific things, and they're comparing it to if I pull you over on the side of the road and ask to search your trunk and you've got 15 locked boxes in the trunk, I can't open those boxes unless I get a warrant. They're stating that it's that type of situation is is his phone. So basically they asked to look at his call history and see if he was logged onto the Google, but they didn't ask to go through the Google pictures and photos, which are basically you have to look at it like locked boxes in a trunk. The photos, pictures, and everything of Maddie and the Google Drive account that had everything doing with Maddie are basically locked boxes in his trunk. And they asked to look at the trunk. Do you understand what I'm saying?
I do. Now, let's go out on a limb a little bit further. Look at all the evidence collection that happened within the home itself. Are they going to try and suppress that evidence as well?
Um, I don't know. They haven't filed a motion for it, but I would think that Jennifer and then gave permission to search the home. But again, I mean, you could compare it to, well, they gave permission to search the home, but they didn't give permission to search each room specifically. Um, I suppose. I don't know what they found in the house, but no motion has been filed to suppress what they found in the house.
Well, I reached out to a friend that is an active attorney in the state of Florida that's in criminal defense, and I was just running some scenarios by them. And they said what it sounds like to them, and he's just trying to gain immunity to both the murder and the CSAM by utilizing the CSAM information in the case to turn it over, like we were talking about yesterday. But that was just a mere opinion in just trying to piece it all together to have a better understanding, not to give a professional opinion or something.
Right.
So I can see the direction that he's trying to take, and find in the public information on his defense attorney. She's got a pretty good dossier going for herself. So she shocked me yesterday knowing what her portfolio looks like versus what she's doing in this case. She did. I'm not impressed.
You're not. I don't know much
Mm-mm.
about her. I haven't dug into her very much. Um, okay, so Hannah said the interrogation video, he confirms he gave consent to them to download his phone. He does confirm that there. We're going to look at what the defense said. I don't know if they call that into, I don't know if they account for that. And plus, the argument could be made, well, he was talking about the second phone, the phone that he handed them in the interrogation. So I don't know. And Hello Kitty, this was a good point, said, but Stephen Stearns gave them the key to the locked boxes when he provided the access code to the entire phone. My question would be then, though, I would say, but did he give them the password to the Google account? Because the PIN for your phone is different than the password for your specific Google account. You know what I mean? Like if I would relate it to the password for the Google account because that's basically the key to the Google account is the password. So if he didn't give them the password, could they argue that? I don't know. Okay.
Under both consent and general Fourth Amendment principles. Number 2, no extingent circumstances justified the extended seizure. While law enforcement may conduct a warrantless seizure when extingent circumstances exist, such circumstances are, quote, few in number and carefully delineated, unquote. They cite Welsh versus Wisconsin from 1984. The state bears the burden of demonstrating that the procurement of a warrant was not feasible because, quote, the exigencies of the situations made that course imperative, unquote. They cite Coolidge versus New Hampshire from 1971. None of the recognized extingent circumstances existed here. First, there was no, quote, hot pursuit, quote, of a fleeing suspect that would justify the warrantless seizure. See United States versus Santana from 1976. Mr. Stearns was at his residence and fully cooperative with law enforcement when Detective Tangler seized his phone. He made no attempt to flee or evade the officers.
So basically they're saying because he didn't run, there was no attempt to flee. Hello Kitty said he waived expectation of privacy on the Google account by having it auto-logged into his phone. I would ask, can we prove he was logged in? That's a good point, though. Mercedes said, but prosecution argues that when he reset the phone and repopulated what it downloaded, there is no way of knowing what photos are from Google and which ones are from your phone. Well, they also argued that the only reason he handed it over was because he reset the phone and he thought that all of the shit wouldn't be on there. Basically, he's a dumb criminal. It's good to see you, guilty of crime. Guilty of crime said passwords on your phone are usually auto-saved so anyone can get into anything once they are on your phone. Right, that's a good point. That's a good point. I would have to ask, was it logged in? But that, yeah, I would think so. I would think that if that's the case, if he was logged into his Google account, then yeah, basically giving them the PIN code to his phone would grant them access to all of that. So yeah. Lena Legato, good to see you. Lena said, wait, them asking to see if he logged into his Google is the same as them asking to see if the trunk is unlocked. The way you could check that is by opening it, and then what you see should be okay to use. Yeah. But we have to run this like we're logging onto our Google account. When I click here, let's do it this way. So I'm going to go to Google right now. Okay, this is my Google account, right? Like, you can't see pictures, you can't see Gmail, you can't see any of that. I have to go over here, sign in, inbox, Gmail. I could even click that, and that's what it is, right? Hold on, let me make sure y'all can see it because yeah. So this is my Google. You can't see anything. Like, check to see if you're logged onto your Google. I'm logged onto my Google right here. Allegedly speculating is logged onto Google. Now, in order to look at Gmail or images, I would have to click these. So, does that matter? Does it make it different? I don't know. I would think so. I would think basically these are two locked boxes on my Google account. But I could be wrong. Hold on. Okay. Guilty of crime said, I think defense is pulling all stops and grasping at straws here. I do too. I believe the judge will rule to keep the info in. I hope so. I do. Click on your photo in the upper right corner. Well, okay, hold on. I put my mouse over it.
That Human Trafficking and Child Exploitation Act that I sent you the link to yesterday, it umbrellas all of it. So I hope he considers that act.
Yeah. So if I click on my name, it gives me all of these. It doesn't give me, it's not showing me images, emails, or anything like that. And even clicking that, I mean, that could be considered another locked box. Because technically, if you want to check and see if I'm logged into my Google, I go to Google and yeah, I'm signed in. Because I can sign out. So therefore, you know I'm logged into my Google. I'm hoping that they use this case for case law as far as child trafficking goes and all of the that new law that y'all told me about in Florida. Hey, one sunny day. Veronica said, I hope he never ever tries to say he accidentally factory reset his phone. That would get him. Yeah, they were talking about that yesterday with the way that you have to do it. When they had the cell phone expert come up. Oh.
Second, there was no imminent destruction of evidence. See Kentucky versus King. They cite Kentucky versus King from 2011. Detective Tangler articulated no specific facts suggesting Mr. Stearns was attempting to or about to delete data from his phone. Indeed, the phone had already been factory reset prior to the seizure, undermining any claim that immediate warrantless seizure was necessary to prevent the destruction of evidence. The mere possibility that additional evidence could be deleted is insufficient to create exigency, as this would effectively eliminate the warrant requirement for all cell phones. They cite Riley versus California from 2014. Whereas here, any purported destruction of evidence had already occurred. Law enforcement cannot justify a warrantless seizure based on preventing what has already happened. Third, no emergency aid circumstances existed. They cite Brigham City versus Stewart from 2006. The state will likely argue that the missing child investigation
I am talking away. Okay. I'm going to go back a little bit, is what I said. And so we can listen to number 3. But basically, number 2, they're arguing extingent circumstances, and they're saying that if you want to say that you took the phone to try to keep evidence from being deleted, well, you can't technically say that because he had already factory reset his phone not once but twice. So there was no imminent destruction of evidence because he had already tried that, yet you were still able to get the evidence for the phone. So therefore, you can't argue that because, I mean, what else was he going to do other than factory reset the phone? Is their argument. Now, I could say, well, the possibility of him throwing the phone in a lake or running over it with a car or smashing it with a hammer could have made the evidence unobtainable. And if he had had the phone for a longer period of time, he might would have tried to do that once he realized that his phone automatically logged back into his Google account. Hello Kitty said Stephen Stearns did his second accidental factory reset right at the stroke of midnight in the hopes of hiding it as an update or something. The fact will prove that he was intentionally destroying evidence. He was definitely trying to intentionally destroy the evidence, but he was unable to, and that's their argument. Like, he had already tried to destroy the evidence but was unable to. But again, me personally, I would say, well, there's still a possibility if he held on to the phone for longer that he would have destroyed it in a way that we could not pull the evidence from it. So it was still necessary for us to detain the device. Wouldn't the officer be covered by a simple blanket statement of "May I look at your phone? No limitations set." Yeah, I would think so, but
Yeah.
I don't know.
Yeah. And Hello Kitty made a good point about the midnight timestamp on the factory reset. If that be the case, then that means Maddie had probably already lost her life before midnight.
I think this was midnight on the second day because remember we've got the audio body cam footage where they go up to the house at 8:30. They are trying to go through Maddie's phone to look at deleted text messages, and he still has his phone at that time. And so it's that night that he factory resets his phone, I think. But I could be wrong. So I think it was the next night, though. Pretty sure, but I could be wrong. If I'm wrong, y'all correct me. Okay, Hello Kitty said, yeah, midnight on the second day. All right.
It's still an
Yeah.
act of guilt.
Oh, yeah, absolutely. Everything he did was an act of guilt of this stupid, sick individual.
They cite Riley versus California from 2014. Whereas here, any purported destruction of evidence had already occurred. Law enforcement cannot justify a warrantless seizure based on preventing what has already happened.
And basically, what has already happened is he attempted to factory reset his phone. But like I said, there's other ways to destroy a phone. I mean, I keep thinking about Delphi, where they're searching in the river for that. I think it's Keegan Klein's phone, and we're never able to find it. Hello Kitty said midnight, the same night they met in Grandma's office and reported Maddie missing. Okay, thank you for that. Mercedes said he reset it hours ago, and there was photos on the phone. That's what they were protecting. Yep. Hey, Southern. I've heard I've heard a forensic detective today that said you can't accidentally factory reset a phone, least of all twice. Everybody knows that, of course. Yeah, they had the cell phone expert prove that yesterday on the stand. The classic one, good to see you, said if the dummy was really smart, he should have simply got rid of the phone devices altogether, knowing cops would eventually come looking for them and him. Oh, yeah. Yep. But he didn't, thank God.
Third, no emergency aid circumstances existed. They cite Brigham City versus Stewart from 2006. The state will likely argue that the missing child investigation created emergency circumstances justifying the warrantless seizure under the emergency aid doctrine. And they cite again Brigham City versus Stewart from 2006. This argument fails. The emergency aid exception requires law enforcement to have an objectively reasonable bias to believe that an emergency exists, requiring immediate action to prevent imminent harm. They cite Missouri versus McNeely from 2013. While the underlying missing person investigation was undoubtedly serious, the circumstances here do not justify a 9.5-hour warrantless seizure. The timeline itself negates any claim of emergency requiring immediate warrantless action. The child was reported missing at 2000 hours on February 26th, yet Detective Tangler did not seize the phone until 1600 hours on February 27th, some 20 hours later. This significant delay undermines any argument that immediate warrantless seizure was, quote, imperative, unquote. They cite McKinney versus Arizona from 1978. If officers genuinely believed emergency access to the phone was necessary, they could have and should have acted much sooner. Even assuming, arguendo, that emergency circumstances initially justified seizing the phone, this would not excuse the failure to obtain a warrant during the subsequent 9.5 hours of possession.
And I'm wondering if that's going to come back and bite them in the ass, because they had 9.5 hours to call the magistrate that was on call, get the warrant, and seize the evidence, and they didn't. And I hope if anything comes of this, I hope that officers remember to do that next time. It's a big problem. Hi, Lana. Lana said, I think the issue is the cloud. The cloud does not belong solely to the owner of the phone, in my opinion. That's a good point. So could you argue that because you put it on your Google account, then Google is partial owner, therefore getting a warrant through Google would give you access to it? Or is a Google account somebody's personal account? And even if that's the case, why not get the warrant through Google to search this specific Google account and wait 9.5 hours to do it? That would be my questions. Yeah, Maddie was still missing during that 9.5 hour time, so extingent situation still existed.
Right.
Yeah. I've always gone back to that was the reason that he drove all the way back home to log on to his parents' Wi-Fi, because he wanted to make sure he had erased everything. I think so.
That he keeps asking, he was in those jail calls, he keeps asking his daddy, has he found certain items, and his mom too, if they found certain items that he had stored in his room, like the dragon and that box and all that stuff. You know, I'm thinking that I'm seriously thinking that daddy's helped out more than what people would give him credit for.
Yeah, I certainly hope not. I mean, obviously I don't know. I wasn't there. I think his dad sees some of his bullshit and like understands that he's full of shit, but that's still his son. But I don't know. I certainly hope not. It would be something to find out that he did. That would just be, I mean, considering that they kept him in the house even at the age he was and always tried to give him a job and always tried to provide for him and tried to make sure he had everything he needed. I mean, the question would be how far would they go for him? And I don't know the answer to that.
And again, they've diagnosed a grown ass man with a very serious criminal profile and are allowing him to use his mental health as a crutch in his defense. I'm sorry, it doesn't excuse capital crimes, especially capital crimes against children, in my opinion. I don't care how messed you are up in the head, it don't excuse it.
Oh no, no. But yeah, they're trying to use the TBI as a defense if this doesn't get thrown out. And yeah, I don't know. There is a correlation between damage to the frontal lobe and primal instincts making people not have sympathy, empathy, compassion, a conscience. I hope it doesn't stick, and I don't think it will, considering that he wasn't even kept overnight. We pulled the information that we do have on the TBI, which is that they sued the people, or the settlement they got, and it was dismissed with prejudice, which means they couldn't file again and try to ask for money or whatever. So considering, I mean, even though that's okay, so that's all we have. We know he didn't stay overnight, and it was the case was dismissed with prejudice. I don't know that it'll work, but I mean, I guess they're gonna try everything they can. Anders said, exactly, I heard about the cloud thing today. They said that most of the content on people's phones is saved on servers around the world. Who constitutes the clouds? That's a good point. I would think a Google search warrant would help. I hope the judge family gives him shit so he focuses on the real matter here. I hope so. Yeah, choices have consequences, absolutely. Tanya, I don't buy he can't feel sympathy because he sure has a lot for himself. Hey, you know what? That calls for.
Boom, 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 bop, bam.
Exactly. Hey, Wolfpack, good to see you.
The feared medical emergency exception to the warrant requirement permits police to enter and investigate private premises to preserve life or render first aid, provided they do not enter with an accompanying intent either to arrest or search. They cite State versus Foltz from 2016. Detective Tangler's own statements reveal investigatory purpose behind the seizure, as she explicitly told Mr. Stearns, quote, I told you I was going to hold on to it and that we would like to download your phone, right? Unquote. Demonstrating from the onset that her intent was to conduct a forensic search rather than address any emergency. Once the phone was secured,
So they're saying that if you want to pull out the emergency that you were trying to find Maddie, it's not an emergency, it's an extensive forensic download, and you're proving that by saying, I told you we wanted to download your phone, right? They're saying that you're not using the phone to basically look and try to locate Maddie. You're getting the phone for a forensic download, which takes more time. It's not an emergency situation, is their argument. I need to quit smoking. I'm hoping I will. That's true. Google is a cloud and accessible through different devices. If they can't use stuff in the physical phone, they should be able to get it from Google. Even Stefan knows it's a cloud. That's a good point. I'm wondering if they'll use that. Kara, forgive me, I don't know what IRC is. The prosecution already got everything they needed from the Google Cloud. I could have sworn I saw a document that they got pics from the cloud account too. I think they did. I think I remember seeing that they got pictures from the Google account or Google Cloud. Well, Google account, and they're arguing the Google account specifically too. So, I don't know. I don't know what differentiates his personal Google account from a Google Cloud where everything is stored. If we can make that differential, I don't know what the appropriate word, but you know what I mean.
Any emergency justification for the warrantless seizure dissipated, and officers were required to obtain a warrant for continued possession and examination. Their failure to do so, despite the availability of an emergency duty judge, demonstrates that true emergency circumstances did not exist. Detective Tangler's own actions belie any claim of emergency. After seizing the phone, the detective made no immediate attempt to search it or obtain emergency judicial authorization. Instead, law enforcement simply held it for over 9.5 hours before seeking consent for a forensic examination.
Fawny, I just saw that you came in here. We played your video. It was really cute. I was saying, I don't know if you saw it at the beginning of the live, but I was saying how Basil would love, I would take the sewing box, and Basil would love to have those cookies. Those cookies are good. We did this Christmas dessert with it this year. I think it's actually up on my page from Christmas for members. But that was a really cute video, Fawny, and I appreciate you sharing that with us. That was so sweet. I like that sewing box with the cookies.
This behavior is inconsistent with a true emergency requiring immediate warrantless action to prevent harm. For a warrantless seizure to be justified under the emergency exception, quote, the person making entry must have had an objectively reasonable belief that an emergency existed that required immediate entry to render assistance or prevent harm to persons or property within, unquote. They cite United States versus Moss from 1992. This objectively reasonable belief must be based on specific, articulable facts and reasonable inferences that could have been drawn therefrom. They cite Mora versus City of Gaithersburg from 2008, and also cite Terry versus Ohio from 1968. Here, Detective Tangler failed to articulate any specific facts suggesting why the extended warrantless seizure of the phone was necessary to prevent imminent harm. The extended timeline, failure to pursue available warrant procedures, and law enforcement's own conduct all demonstrate the absence of an objectively reasonable belief in an emergency requiring an immediate warrantless seizure of the phone. Fourth, there were no, quote, community caretaking, quote, circumstances requiring immediate action. They cite Caddy versus Dombrowski from 1973. The phone itself posed no danger to the public, and its seizure was clearly investigatory rather than for community protection purposes. Fifth, there were no extingent circumstances related to officer safety. They cite Meline versus Bowie from 1990. The phone posted no threat to officer safety, and Mr. Stearns displayed no aggressive or threatening behavior that would justify its immediate seizure. Instead of demonstrating recognized extingency, the record shows that Detective Tangler had ample time and opportunity to obtain a warrant through the Ninth Circuit's established emergency duty judge system under Administrative Order 7-84-11, which has maintained a 24/7 emergency duty judge protocol for nearly 40 years, specifically to handle after-hour warrants.
And that's what I was talking about earlier, how there's always a magistrate on call, and you call them to the police station and you have them come in and give you the search warrant. Oh, Wolfpack, I'm so sorry. I'm glad that you were able to quit. I'm working on it. Blue Sapphire says, deleting history after fact makes me feel he didn't plan it. A panicked afterthought. Did Jen delete things on Maddie's phone, though? Did Jen tell Romeo to reset like she advised an attorney? Yeah, I think she told him to reset the phone. I think if she was able to delete stuff off of her phone or Maddie's phone, they still would have been able to pull it. But I don't even know if I think they did take her phone, actually. I don't know when the judge is expected to make his ruling. I am checking right now to see if anything's in. I know when we started the live, nothing was in yet. Stephen Sturds would have signed a written consent, but she didn't even do that. You're right. And when I look at the homicide indictment, they have a signed written consent from the landowner to go on his property to remove Madeline's deceased body. I mean, they got consent for that, but you didn't get signed written consent for the cell phone. So, I don't know. So how many people here have looked through your partner's phone, not being nosy, but like scroll through pictures? So Jen Soto, never seen his phone and contents. Nope, don't buy that either. No, ma'am. So Tanya, I don't know. My husband works a really hard job. He comes home, he goes to bed. I don't go through his phone. I have gone through his phone, but it's not something I do on the regular. But it's because I know that he wouldn't have time to do anything nefarious, cheat on me, whatever. But I probably should, I suppose. The classic one said technically their investigation was not in an emergency status, yet it was being investigated only as a missing persons report. There is a difference. Yeah, I would think, though, that the emergency status would be evident because there was a missing juvenile, I would think. Just rewatched the beginning. Aw. Yeah, now we know where the cookies go.
The United States Supreme Court has emphasized that the ability of telephonic warrants is relevant to the exigency analysis. They cite Missouri versus McNeely from 2013. Here, Detective Tangler's complete failure to pursue these readily available warrant procedures during the 9.5-hour seizure, during which Mr. Stearns was completely deprived of his ability to communicate with family members or access any of the phone's essential functions, is particularly erroneous and negates any claim of extingent circumstances. Despite the well-established warrant system and the availability of an emergency duty judge at 1:30 a.m., the detectives deliberately chose not to utilize this source, further demonstrating the unconstitutional nature of their actions. 3. All evidence derived from the unlawful seizure must be suppressed. When consent is obtained after illegal police activities, such as an unauthorized seizure, the unlawful police action presumptively taints and renders involuntary any subsequent consent. They cite Norman versus State and Bailey versus State from 1975. The consent will be held voluntary only if there is clear and convincing proof of an unequivocal break in the chain of illegality sufficient to dissipate the taint of prior official illegal action. The fruit of the poisonous tree doctrine requires suppression of both primary evidence obtained from the initial illegality and secondary evidence derived from the exploitation of that illegality. They cite Wong Sun versus United States from 1963. The relevant inquiry is whether the evidence was obtained by exploitation of the initial illegality or by, quote, means sufficiently distinguishable to be purged from the primary taint.
That's
unquote.
funny to me.
The Florida Supreme Court has consistently held that evidence discovered by exploiting previous illegal conduct is inadmissible. They cite Craig versus State from 1987. Here, there was no break in the chain of illegality between the unconstitutional seizure and the subsequent searches of the phone. The extended deprivation of Mr. Stearns' phone created coercive circumstances that led to the midnight, quote, consent, unquote, for its forensic examination. Any purported consent was inexplicably intertwined with and the direct product of the illegal seizure. The Google warrant and all derivative evidence were direct products of the initial unlawful seizure, as law enforcement would not have had access to the phone's data without first illegally seizing and retaining it. Therefore, all evidence obtained through exploitation of this unlawful seizure, including the phone's contents, the Google warrant results, and any investigative leads developed therefrom, must be suppressed as fruit of the poisonous tree.
We're going to look up that doctrine in just a second. Lana said law enforcement had knowledge of a dead child in his car. I say that is the reason to see his entire phone. And you know what? At that time, they had, I don't know if they knew she was deceased yet, but they do reference him on traffic cameras in areas that he said he wasn't at during different time frames. They were talking because they reference how he had been lying about where he drove that morning, and they had seen Madeline in his car. So did they know that she was deceased yet? And if so, why didn't they use that to
Right.
to obtain the phone? That's a good point.
And also, I'm sitting here brainstorming a few things. They're trying to suppress the evidence collected off that phone, saying that they collected illegally, right?
Yes.
If those images were shared with anyone else, that opens the door for another access point to have evidence collected or reaching out to those senders,
Yeah.
those recipients of that information. So they can
Yeah.
suppress this. They can suppress this, but it doesn't mean that there's a door of opportunity for reentry.
Yeah. Yeah, that's a good point. It might be hard to track down all the people or, get people for each specific image, but yeah, it's entirely that would be entirely possible.
Conclusion. Detective Tangler's warrantless seizure of Mr. Stern's cell phone represents precisely the type of unreasonable government intrusion that the Fourth Amendment was designed to prevent. The 9.5-hour deprivation of an essential communication device without consent or extingent circumstances violated fundamental constitutional principles. All evidence obtained through exploitation of this unlawful seizure must be suppressed to uphold the integrity of the Fourth Amendment and deter future violations. Wherefore, the defendant respectfully requests this honorable court, 1, to set this matter for an evidentiary hearing pursuant to Florida R Criminal Code P. 13.90 subsection H subsection 3. Number 2, suppress all evidence obtained from and derived through the unlawful seizure of his cell phone. And 3, grant such other relief as this court deems just and proper. And it was signed by Melissa Vickers, public defender.
Okay, so that was the warrantless seizure. We're going to jump to the state's response to that. I'm going to pause
State of Florida is the plaintiff.
To the warrantless seizure.
I get what Hannah's saying.
Okay. Yeah, I was about to read that.
Yeah, I get what she's saying. You go ahead and read it.
Oh, okay. She said, Genevieve, they are saying that PCA for Google search warrant was based of illegal phone seizure. So if they get the phone squashed, they lose the legality of the Google search warrant.
Not if someone comes forward saying to show proof that they were the recipient of the material. That hypothetically, that would be like if AS sends me a picture and they suppress that picture or that image or that text message as evidence. But then I come back and say, yes, I'm acquainted with her. I remember getting this. Here's proof that she sent it to me. And then it's re-entered as evidence as them being the recipient of the material. It can be re-entered. That has happened before.
Yeah. Right. Like she said, so like again, if I send Genevieve a picture of, I don't know, 500 pounds of marijuana, and then the police take my phone illegally, and the judge rules that you can't. And I sent a picture to Genevieve. I apologize. I left that out. So I got 500 pounds of marijuana. I take a picture, send it to Genevieve. The police find out. They take my weed. They take my phone. The judge rules that they took my phone illegally. Jen could go to the police station and say, look, she sent me this picture with 500 pounds of weed, and here you go. And then they could say that they got it from Jen and my IP address or something to that effect, right?
Right.
Okay.
And that's how a lot of narcotics investigations are passed through passed from the court. That's how a lot of indictments are obtained.
Mm-hmm. Oh yeah. Once they knew he lied about his trips from license readers, they should have requested the warrant, in my opinion. Yeah, I think if they had gotten a warrant at that point, we wouldn't be going through this. But they're trying everything. I mean, they filed over, I think it was a couple months ago, it was over 52 motions on this case alone. They're working their ass off on this. The roommate Stephen was recording. That's a good question. I think I heard that they talked to some people on YouTube in the jail phone calls, but that's about all I've that's about all I've heard. I am not growing marijuana. Honestly, I'm not that good at growing stuff yet to try to grow some of that, but I don't smoke. If I
And for
smoked,
the
I probably
record,
would be.
if she had sent me a picture of 500 pounds of marijuana, You think I'd be dumb enough to turn in the evidence because she did it? That's incriminating myself. But then again, that's another factor here.
Yeah.
Are they gonna have somebody willing to incriminate themselves on the lesser plea of involvement, just to convict him as a result of a child being dead from his actions and activities?
Right, because if somebody has a picture like that, obviously he's sending it to them because they look at things like that or whatever. So are they going to indict themselves? Good point. Okay, so this is the state's response specifically to the unlawful seizure.
State of Florida versus Stephen Michael Stearns as the defendant. State's response to defendant.
I apologize, my nose was stuffy that day.
Motion to suppress evidence obtained from unlawful seizure of the cell phone. It reads, comes now the state of Florida by and through the undersigned assistant state's attorney and hereby states as follows. Procedural history. The defendant was arrested pursuant to an arrest warrant in the above styled case on February 29th, 2024. On March 11th, 2024, the state filed an information charging the defendant with 8 counts of sexual battery on a child under 12, 5 counts of sexual battery with a child 12 to 18 from the familial or custodial authority, and 7 counts of lewd or lascivious molestation, and 40 counts of unlawful possession of materials depicting sexual performance by a child, 10 or more images on each charge. The state provided discovery to the defense on March 20th, 2024, and discovery has been ongoing. On February 6, 2025, the defense filed a motion to suppress evidence obtained from unlawful seizure of cell phone. The motion alleged violations of the 4th Amendment to the United States Constitution and Article 1, Section 12 of the Florida Constitution. Statement of facts. On February 26, 2024, what I assume to be Madeline Soto was reported missing to the Orange County Sheriff's Office by her family.
So we're going through the facts that the defense is that the prosecution is laying out now. I apologize. Hello Kitty said, wait until we see what Telegraph warrant uncovers. I think Stephen Stearns logged into Telegraph trying to delete photos too. The problem with that is that Telegram deletes everything. It's an encrypted server and erases everything once you after a whatever time period. That's why these pedophiles use that app a lot. So I don't know that they'll be able to pull anything from it. See, I'm concerned that he recorded himself possibly committing a homicide, and it could be on that. It could have been on there. But I don't know if they would even know if that's something that if it happened, anybody would know. If it's since been deleted, I don't know.
The family contacted law enforcement at approximately 4:30 p.m. There were 3 calls made to the Orange County Sheriff's Office prior to deputies arriving. At approximately 7:35, Deputy Joseph with the Orange County Sheriff's Office made contact with Jennifer Soto, the defendant, and members of Ms. Soto's family. All individuals were present in the lobby of the business building in which Ms. Jennifer Soto's mother worked. Deputy Joseph inquired as to the identifying information for Madeline from Ms. Soto and the family. The defendant stated he had dropped Madeline off for school that morning. The defendant described Madeline to have been wearing a green hoodie, white Crocs, and either blue or black pants. Deputy Joseph was also told that Madeline had not taken her cell phone to school that day and only had her school computer. At approximately 7:47, Jennifer Soto provided Madeline's phone to law enforcement to review. Sworn and written statements were collected from the defendant and Jennifer Soto on February 26, 2024. The defendant's sworn and written statement states as follows. Quote, dropped off about a block or so from school sometime between 8:25 and 8:40. Turned around and headed back towards town. I watched in my rearview mirror as she made her way in the direction of the school. She was busy searching through her backpack for something but seemed to still be moving towards the school, so I carried on with my day. I stopped by a nearby vape shop, but it was closed, so I went home and left about an hour or so later to check the shop again. It was open and I bought my vape juice and I returned home, relaxed with Jen for a while, later went out in the afternoon for a few more errands. I returned home around 2:30, unquote. Jennifer Soto's written statement states as follows, quote, today around 8 a.m., I saw Madeline getting ready for school. I'm not sure what time they departed. Stephen Stearns took her to school and dropped her off close to school on Town Loop Boulevard between Town Center Boulevard and Hunters Park Lane around 8:30 to 8:45. She never made it to school. I went to school around 4 p.m. to pick her up and she never came out. I searched the area, went to my mother's office to look for Madeline and could not find her, unquote. At approximately 9:05 p.m., while accompanied by law enforcement, the defendant drove his vehicle to the area he claimed to have dropped Madeline off for school at. The defendant stopped in the middle of the road and got out of his vehicle. During this time, law enforcement provided defendant with Madeline's cell phone.
You know, Mercedes said the amount of time it took the police to respond was disgraceful and should be addressed. That does bother me very much, that it took them like 3 or 4 or 5 hours to respond. I don't know the exact time frame. I'm sure I have it somewhere, but it was several hours. I know that, and I understand that there was 2 children missing from a park, but there should be enough officers to address both situations. Like, what if somebody's just running through, snatching kids off the sidewalk, one right after the other after the other? Are you still going to be stuck looking for the first kids while 5 more kids have been abducted because they're waiting for you to make it out there? Like, that bothered me too. Lori said it still eats me up that Stephanie got told they were in the room late at night playing games. The roommate or the sister? Yeah, it's worrisome that he told them that they were playing games. Yeah, he was playing his sick little games, and poor Madeline had to suffer through that, and that's absolutely disgusting and disgraceful.
The defendant claimed that they were standing in the area in which he last saw Madeline. Deputy Joseph made contact with the church in the area and went through the video surveillance. At approximately 12:30 a.m., Officer Clark arrived at the home of Jennifer Soto and was greeted by Ms. Soto and the defendant. Law enforcement was actively searching for Madeline and was unsuccessful. By all accounts, the defendant was the last person to have seen Madeline on February 26, 2024. On February 27, 2024, at approximately 12 p.m., Detective Hunt with the Orange County Sheriff's Office conducted an audio recorded interview of the defendant.
You know, that's a good point. Carolina said Detective Tangler asked and got verbal consent twice, so for me it's a wrap. It's the same as when Deputy Jensen asked Jen to see Maddie's phone. Think about it. Would that have been illegal? I starred your comment so I won't forget it, or I won't lose it. I want to look back at we're going to look back at the body cam where they asked to see Madeline's phone and see how they asked for it, what they did and all that, and if they only looked at the specific things that they asked to look at that time. Hey, Loudmouth. Good to see you. Boomer said the boyfriend of Jen's sister had to go out and look for the cops to bring them back to the office. Yep. Jen Soto gave them the key to the door and is just as accountable, in my opinion. Jen Soto needs to answer for a lot of the roles she plays in this, in my opinion. That's just my opinion, though.
Detective Hunt swore the defendant prior to questioning him. The defendant reiterated that the last time he saw Madeline was when he dropped her off for school the day prior. During this interview, the defendant told Detective Hunt that he did not recall the exact time of the drop-off because he, quote, left his phone at home, unquote. It was also during this interview that the defendant stated Madeline slept alone with him in the upstairs bedroom so, quote, Jen could get better sleep, unquote. The defendant also told Detective Hunt that Madeline left her phone at the residence as well when they left for school. At approximately 7:16 p.m., an audio recorded interview with the defendant was conducted by Detective Tangler and Acosta. The interview occurred at the address. The defendant was not in handcuffs and was free to leave. The 2 detectives who interviewed the defendant were in plain clothes. The defendant stated that he and Madeline left home between 7:30 and 7:45. The defendant again reiterated that he dropped Madeline off a little way up from the school the day prior. The defendant detailed their route on the way to drop her off. The defendant indicated that he tried to go to the McDonald's near the school. However, he did not stop at the McDonald's. The defendant estimated he dropped Madeline off at approximately 8:20 to 8:40. At approximately 7:35, after the defendant relayed all of this information, the following exchange occurred between Detective Tangler and the defendant. Detective Tangler said, "Do you mind if I look at your maps real quick?" Stephen said, "Yeah, that's fine." She said, "Thanks." The defendant unlocked his cell phone and handed it to Detective Tangler. There's some more clarification with Detective Acosta on the route the defendant took to reach the school and the location of where he claimed to have dropped Madeline off. Then Detective Tangler has the following conversation with the defendant.
Now, remember yesterday in court, the judge said that since I guess the defense is accusing the state of doing something wrong. It lies on the state to prove their case, so that's why they're going through it like this. They're laying out everything because it's on them to prove that they didn't take the phone illegally. So they're going through and basically giving us the whole rundown. A name here, good to see you, said Jen Soto should be charged with child endangerment at least. She knew and allowed it. Definitely didn't try to stop him. I think a child endangerment charge, neglect, something to that effect is definitely in order, in my opinion. Heather said, an emergency situation requiring swift action to prevent imminent danger to life or serious damage to property, or to forestall the imminent escape of a suspect or destruction of evidence. So, yeah, and their argument is the destruction of evidence specifically. If he was going to be able to destroy evidence, he would have already done it with the factory reset. But again, like I said earlier, he could throw the phone away, stomp it, run it over with a car, hit it with a hammer, and then you might have an issue without a Google search warrant to get the account. With Jen, they were asking about running off to the woods, and Jen started searching, and for some reason she knows where Madeline calls her a B word, which always makes me laugh. Yeah. Extingent, an emergency situation requiring swift action. Oh. So repeat. I will never, ever hand my locked or unlocked phone to law enforcement here in Utah. They have driver's licenses on our phones now, but not mine. No, thank you. Yeah, you got to be careful, even if you didn't commit a crime. I think they will charge her with something after trials if they ever get here. Yeah. Good to see you, Smoky Mountain.
Detective Tangler said, do you mind if I just take a picture of your history? Stefan said, yeah, that's fine. The defendant and Detective Acosta discussed what time classes begin at Hunters Creek Middle School. Their conversation continued.
Hey, I'm going to grab some coffee real quick. I saw that you were unmuted, Jen, so just a second ago. So if you wanted to say something, I wanted to let you know I'm going to step away for just a second.
Go ahead and get your coffee. I will let it play. This is interesting.
Okay.
Detective Tangler said, what kind of phone is this? Stefan said, S23 Ultra, I think. She said, I don't know how to work this thing. He said, I'm sorry, I barely know how to work it myself. Detective Tangler said, I'm an iPhone person. Stefan said, oh. Detective Tangler said, is it okay if I go in your settings real quick? I just want to see if you're logged onto your Google. Stefan said, I'm not logged onto my Google with that, actually. She said, is it okay if I check? He said, yeah. There was some further discussion between Detective Acosta and the defendant regarding what type of digital devices Madeline had and where she kept them. Detective Acosta then had the following conversation with the defendant. Detective Tangler said, hold on, I don't know how to use this phone. Sorry, I don't mean to interrupt. A brief conversation occurs about Madeline's behavior. Detective Tangler said, is this what you use to go places? Stefan said, yeah, go places, search addresses, look at store hours, write reviews. It's a pretty new phone, though. Detective Tangler said, when did you come back to help Jen? Is that her name? Stefan said, what do you mean? She said, because you live down south. When did you come back up north to help her? Stefan said, I just got here this weekend. She said, do you remember what day it was? He said, Sunday. Sunday was her birthday party. So yeah, it was the evening after her birthday party, Sunday. Detective Tangler said, okay, do you remember what time you got here on Sunday? He said 8 to 8:30ish maybe. She said, okay. He said, just in time to make sure she was doing all her nighttime routines, waiting for her mom to get home. She said, you live in Northport, right? And he said, yeah, I split my time between the two places. She said, is that on Sung Street? He said, yeah. She said, that makes sense. You have a lot of Snug Street on here. He said, yeah, I split my time between the two. Detective Acosta implied as to whether the defendant and Jennifer Soto went anywhere to look for Madeline the night before, February 26, 2024. The defendant denied knowing whether they went to look for Madeline anywhere because he had taken an Ativan the night before because he had been so worried. Detective Acosta then went through the details of the directions for the route that the defendant claimed to have taken Madeline to school. The defendant then went through this discussion again, but this time included time frames. Detective Acosta then indicated that the defendant's vehicle was not where he indicated it was according to the traffic cameras in the area. The defendant then indicated he went back home because he forgot his gate clicker. At 7:53, Detective Tangler handed the defendant his phone back. Immediately after handing the defendant his phone back, Detective Tangler stepped away from the defendant. Detective Acosta stayed with the defendant, and they continued speaking. At 7:57, Detective Tangler returned and had the following interaction with the defendant. She said, "Can you unlock this one more time, please?" He said, "Sure." She said, I have a question." He said, "Yep." She said, "Sorry, are you guys done? The other detective mentioned that you did not have your phone yesterday." He said, "Correct." She said, "Tell me about that." He said, I left my phone home in the morning too. I was so busy writing her or Madeline to get us out the door on time that I left my phone. She left her phone. We both left our phones."
That was interesting to me that they left that in here, that I was so busy writing her or Madeline to get us out the door on time that I left my phone. That was redacted in the first one, and I remember in a previous live stream us discussing trying to figure out exactly what he had said right there. And we thought, like a couple of you had said, did he just say he was writing her out the door? And we said no. We thought it was no because we listened to it again and thought that wasn't, I remember thinking that wasn't what he said, but it is what he said because, I mean, this is the prosecution typing this out in a legal document, and it said several times. He literally said, "I was so busy writing her or Madeline to get us out the door that I left my phone." And we also know that he said she thought of, I mean, thinks of me as a dad, and a couple of times he slipped up since then. But I found that really interesting.
Yeah, and I noticed that whenever y'all were talking about that day about the terminology of writing and writing, RIDING and WRITING,
Uh huh.
you know, in the South, riding someone's ass means you're hot and heavy on them, trying to keep them motivated, and that's the way I took that statement.
Yeah. I don't, I mean, I was so busy writing her. I mean,
So I can see that being a motivational term with a teenager trying to get them out the door because you're in a hurry to get out the door. I'm not
yeah,
making excuses, but I can see
no.
the use of terminology here.
Yeah, and I'm glad you pointed that out because I can see what you're saying. I wouldn't have seen it like that. I mean, I would think, personally, I would think I was so busy riding her ass to get her out the door, but that wouldn't make sense either. So I can definitely see what you're saying. Yeah, that makes sense. And I hope that's what he was referencing there. I hope it wasn't a Freudian slip. And I would have never thought about that had you not said that. So I really appreciate you saying that.
Yeah, that's just the way I take it because I ride my kids' ass all the time.
Yeah. Yeah, I ride my kids' ass too sometimes. Regardless, the decision on the phone and Google evidence, Stephen Stearns will never be a free man another day in his wretched life. Okay, yeah, I agree. As long as the phone evidence doesn't get thrown out and the Google Drive evidence doesn't get thrown out, if they do, then I think the death penalty's off the table for the homicide. But if they can prove the homicide, he's more than likely going to be in prison for the rest of his life. So, I mean, that's good. Okay, Mercedes said, wait, now I'm a bit confused on the timeline. Did they sleep in the house on the Monday night and the hotel on the Tuesday night? I believe so. Go with what this document says because this is from the prosecution. There was no, Heather said there was no interrogation at the complex. He was free to leave. He was free to say no. When they found that his timeline was wonky and watched the CCTV at the complex, boom, discovered. Yep, and they're going to reference that. Hey, Shraddha. Lastly, before we get back to it, the classic one said again, the Ellies did handle the investigation at the time of confronting Stephen Stearns as such. In addition, they asked to see his phone. They should have handled it as extingent, but they didn't. Yeah, the issue is the warrant and all that. I hope not. Smoky Mountain Mermaid said, I really think he's going to get out of this somehow. I hope not, but I'm concerned. I won't lie.
Detective Tangler said, "Did you have your phone when you went to the smoke shop?"
Oh,
He said, "No, not the first time after I dropped her off."
were you trying to say something, love?
Yeah, y'all were talking about who was it asked the question about did they sleep in the house that Monday night? Did
Oh,
we
yeah.
ever catch what time the roommate left that Monday morning going out of the home?
She said sometime between, I want to say 7:30 and 7:45, or 7:45 and 8. I would say between 7:30 and 8, but my mod Jenny Jen, I'm sure she'll tell us in just a second. She knows all those times. She keeps up with that really good.
Well, here's what I'm thinking. Let's just say 8 o'clock. Let's say that they had a time frame between 8 a.m. in the morning. We both know that both Jennifer and Stefan were in and out of the condo from 8 a.m. until the time Jen left, claiming to go and pick Maddie up from school. That's that's 10 hours. 10 hours that they could have possibly worked together on cleaning, tampering with evidence.
Yep.
They were working together. It's
Oh yeah,
obvious.
I believe so.
Because if she came home from work at 11 o'clock at night on Sunday night and she slept all night, you know damn well she knew what the hell was going on from the hours of 8 in the morning until she left to make it look good on her picking that kid up from school.
Yeah, I mean, I don't think that he could have sat there in front of her and played her face that long to that extent. But I mean, he was gone for a majority of the day and she went to her blood appointment, but I don't believe it. I think she
Uh,
absolutely knew.
yep, and I think when she left to go to that blood appointment, she utilized that time that she was out of the house to meet up with him somewhere else and possibly dispose of some evidence.
Yeah. I mean, if you're sitting in a house together, you're not communicating on the phone necessarily, especially if you don't want that on the phone. You're just going to speak to each other because at that point in time
Right,
nobody suspects anything and there's no cameras.
right.
So,
Yep.
Hello Kitty said the death penalty is specifically tied to the homicide charges. So the issue is that in order to give him the death penalty for the homicide, they've got to prove that he is been convicted, like he's basically a menace to society. He's got several charges. He's previously been convicted of a felony, things like that. The only thing he has on his record, I think, is some traffic tickets or something like that. So if they're trying to get him on the CSAM to get justice for Maddie, number one, and number two, to make him a felon, to make him a convicted felon. So when they go to trial for the homicide, he's a convicted felon. Therefore, the death penalty's on the table, from what I understand. So if this is thrown out and he doesn't get charged as a convicted felon, then when they go to trial for the homicide, he doesn't have a litany. He's not already a convicted felon or like has a litany of other charges. They can say he's been a good member of society because he's only got a couple traffic tickets, and therefore the death penalty would be off the table and he would be facing just life without parole, LWOP. From my understanding. Yeah, aggravating circumstances. Thank you, Boomer. I think you were referencing
There-
that.
There's a lot of circumstantial situations evident too.
Mhm.
And this is going to
Absolutely.
go on for a while. This is going to go on for a while.
Yeah, I think so. I didn't think that he was going to continue it. He really surprised me by continuing it till July. Um,
Well, this happened yesterday. So yesterday was what, April 22nd, 23rd?
23rd. Mhm.
Okay, so April 23rd. So what's the June date? What's the deadline? What's the date for the June 2nd?
Uh, hold on. Actually, I did just pull what they had on the court website, so I'll pull that up real quick and we can be positive on it. Hold on just a
I
minute.
was thinking June 2nd was the pretrial. But still, my point is this. You've got 30 days to reach a decision on the motion for an answer. Well, that would
Mhm.
be April 23rd. There's 30 days in April. So that would give you till May 22nd or May 23rd for the deadline to get that motion or that answer filed. Well,
Yeah.
then you've got from May 20, just to say May 23rd, let's give or take a date. May 23rd until June 2nd. That's just 2 weeks. That's 2 weeks to get everything prepared for the pretrial presentment. And then from May, back it up to May 23rd again until the actual court hearing for, what was it,
July.
June,
So
July?
pre-trial is July 2nd and jury trial is July 14th.
So the judge is giving them 30 days to get an answer and an additional 30 days to appeal the answer
Yeah, that makes sense
before
because
they proceed.
there was a June 30th deadline for something. I remember seeing that yesterday. So yeah, that makes sense.
Yep. So that's what they're doing. So there's 60 days pending, people that are listening, paying attention, that a lot could surface between now and then.
Yep. Yeah, they have several other motions, and I got a feeling a lot is going to surface. So real quick, from yesterday, the I've got two documents that we'll talk about real quick since we were referencing that. This just tells us that his court dates for the pretrial is July 2nd at 9 a.m. with Judge Carson, and the jury trial is the 14th with Judge Carson. The appearance is felony court minutes order, hearing held on the following motions: defendant motion to suppress evidence obtained from Google search warrant, unlawful seizure, and unlawful search. Defendant present with counsel, sworn and testified for the defense. He was Stephen Stearns. And then for the state yesterday was Francis Hunt, Miss Tangler, Mr. Acosta, Mr. Stamek, and Heller. The exhibits 1 through 3 were entered into evidence. Arguments were made by both parties. Court reserves ruling on all three motions. Court will issue a written ruling. Court Exhibit A to be held in evidence by the clerk of court for appellate purposes for basically the appeal. Pretrial and trial reset based on unavailability to try case within current trial period. So they extended it because they weren't going to have enough time to try the case in that amount of time. And yeah, this was what I was just talking about. All pretrial motions must be submitted to the court by June 30th, and that gives them 2 days before before pretrial to have their motions submitted, and that was yesterday in courtroom F. And now I'll pull up the second document that I had real quick, and we'll get right back to what we were doing. I think the second document is the evidence entered. I get excited too when I see that evidence. It'll say evidence, but it's not what you think, unfortunately. So this is telling us what the evidence release and receipt. Deputy Clerk of Osceola County Clerk's Office hereby released the items to the judge on yesterday, and it was a CD interview with Stephen Stearns from Osceola County Sheriff's Office Detective Hunt. CD interview with Stephen Stearns ×2, or that's the second one, and then the affidavit for search warrant was given to Judge Carson yesterday in reference to these documents we are going over. Hey, everybody coming in.
Now, another quick question.
Mm-hmm.
They're trying to suppress the Google search. Has there been any new warrants issued for any other platform that he was communicating on?
Not that I have seen so far.
Well, even if they suppress the Google search for it to be deemed a Fourth Amendment violation, if they went ahead and proceeded with filing warrants for other media platforms that he had access to and exchanging these, it's just going to be the Google information suppressed if those warrants are active.
Right, I think.
That's what I'm saying. They're compiling information. So if the motion is only to suppress the Google images, that doesn't mean that they can't utilize other images shared on other platforms. And there may be enough actually. There may be enough actually with some of the darker web associated platforms that he was doing this on to hold enough evidence to continue with the CSAM. If they're trying to suppress the Google searches alone, hey, that's minute compared to what they may already have warrants on and getting the other information.
Yeah, it could be. It would all depend, yeah, on what they have, and we aren't privy to that. So it absolutely could be. I'm sure they are searching other avenues to to make sure they have the information in case this motion is granted. I'm sure they're already trying to figure out other ways to say they obtained the information or get it another way through other platforms, dark web or whatever, so that they can basically say, okay, well, you said that we had to suppress everything obtained from the phone and the Google search warrant. Then we're going to go through and get this evidence from the dark web, from Telegram, from people he sent these pictures to, exactly like you were saying. Yeah, I would think so.
If I was without it, I got my phone and went back to the smoke shop. She said, okay. He said, later when I got home, she said, okay, I also noticed I was checking your call history and I noticed that you don't have anything before this morning. Is that usual on your phone? He said, no, it's a new phone. Stupid. I went to do an update yesterday morning and I don't know what the fuck, pardon me, I don't know what the heck I did, but somehow during the massive OS update, I managed to factory reset my phone and lose all of my contacts and all of my information. She said, uh-huh. What time was that? Do you remember? He said, oh, sometime while I was hanging out with Jen. Jen might know. I looked at her and I just said, what did I just do? Detective Tangler said, okay. He said, she might know better. I don't know what time it was. It was when I was here with Jen. She said, okay, I don't think I have any other questions. At approximately 7:59, Detective Tangler advised the defendant that law enforcement was going to hold on to the defendant's phone. The defendant was told he would receive it back, quote, when we are done, quote. It was at this point that the defendant's phone was seized by law enforcement pursuant to this investigation. On February 28, 2024, at approximately 12:16 a.m., Detective Tangler and Detective Acosta conducted a second audio-recorded interview of the defendant. During the beginning portion of this interview, Detective Tangler advised that law enforcement had been going through Madeline's cell phone and noticed a lot of conversations between her and the defendant. Detective Tangler asked the defendant to advise as to what type of relationship he has with Madeline. The defendant stated, quote, she thinks of me as a dad, unquote. Less than a minute into the...
I apologize. I was a little late on pausing that. So here I found this interesting as well, where it says Detective Tangler advised that law enforcement had been going through Madeline's cell phone and noticed a lot of communications between her and the defendant. Detective Tangler asked the defendant to advise as to what type of relationship he has with Madeline. So I'm thinking that they got something off of her phone, because even with a lot of communication between the two, I don't know necessarily that you would ask to advise what type of relationship they had unless you saw something concerning, like the parent coin or something like that, to say what kind of relationship do you have with this child. Normal talk like between a stepfather and a stepdaughter would not negate them asking what type of relationship he has. So I wonder what they saw on Madeline's phone. Hey JGR, good to see you. I'm still shocked that video with her, the names and the similarity is out of this world to me. Are you talking about the one Grish did? Yeah, it's interesting. Grish puts out some very interesting stuff. Boomer said all three detectives described him as normal and not distressed. And that's going to play a role too.
When was
conversation
Madeline's father
Detective
notified?
Tangler has...
I'm so sorry, sweetheart. What did you say?
When was Madeline's father, actual father, when was he notified?
I think that night, I think she called him and said, hey, we can't find Madeline. Right, because, okay, remember in the interview where they're in Mom's office, Stefan, he answers the phone and says, hey, I can't talk right now. And I think he says, hey, Tyler. That was in one of Grish's first videos where he points out that he's answering the phone. From what we gather, it's Tyler calling Jen. Jen hands the phone to Stefan, and Stefan basically says, we can't talk right now. We're basically talking to the police. So at that point, he knew, it might have been during that interview that he was notified, and he was calling back.
Lord, what a hell of a way to find that kid.
Yeah. And then to find out on top of that what this man has been doing, somebody that you don't really have say-so in who your ex dates, and you're thinking your ex has the best welfare of her child at heart, and to find out not only that your child's missing, but that this man has been doing this all along, and then to later find out that he is allegedly the one who committed the homicide, like, my heart goes out to him. Tyler was the one who asked her to call the police. Okay.
Oh, really?
It is.
Okay, so he was. Really? Well, see, that again, it just goes back to her cognitive ability. Any normal, rational, thinking mother is going to go into panic mode.
Yeah. Yeah, so...
That's what I'm saying. The whole damn day, they planned this shit out. They both knew what had happened to that kid, and they were covering their asses. Is all they were doing.
I think so. Do you hear Mac Daddy? Shroud said
I did.
that
I heard him.
You did? I think he's under the window.
Yeah.
Actually, he is. The window's shut right now. That concerns me. If y'all hear that, y'all must hear the air. I hope it's not too loud. Shroud said the disc supplied by Chris has 30,000 images, in my opinion. I believe this is verified, but I can't. Yeah, so I think it's 35,000 images, but like I was saying earlier, he's not the perpetrator of, he's not the one doing whatever's happening to those poor victims in that video. So I don't know. I mean, he can be held accountable for it, but I don't know to what extent. Jim planned her panic attack. Why couldn't she phone the police? Yeah. Good.
Right.
All great questions.
The following exchange with the defendant. Detective Tangler said, I'm sorry, I don't mean to cut you off. Your phone. I told you I was going to hold on to it and that we would like to download your phone, right? Stephen said, okay. She said, is that something I have your consent to do, or do I need to get a search warrant for your phone? He said, it should be fine. She said, you're okay with us going through your phone? Stephen said, yeah. She said, okay, can I have the PIN to your phone? Stephen said, 42586. She said, 42586. Okay, perfect. Thank you so much. He said, uh-huh. Law and argument. Consensual search of cell phone during interview on February 27th, 2024. Warrantless searches are per se unreasonable pursuant to the 4th and 14th Amendments unless there is a recognized exemption to the warrant requirement. They cite Ferrier versus State from 2002, Katz versus United States from 1967. Consent is a recognized exception to the warrant requirement. The standard for measuring the scope of the consent given under the 4th Amendment is objective reasonableness, citing Florida versus Gimeno from 1991. The state has the burden of showing by clear and convincing evidence that the defendant's consent to search was freely and voluntarily given. They cite Norman versus State from 1980, Bailey versus State from 1975, Saganoa versus State from 1956, Taylor versus State from 1978. For a search to be deemed involuntary, the court must find that the defendant's will was overborne and his capacity for self-determination critically impaired. Citing Cox versus State from 2008, quoting Scheckenkloth versus Bustamante from 1973. Detective Tangler conducted an interview of the defendant on February 27, 2024. The interview began at 7:16 and it lasted approximately 44 minutes and 24 seconds. Present during the interview was the defendant, Detective Tangler, and Detective Acosta. The interview occurred outside of the residence, which had been secured pending a search warrant at that time. The defendant was not in custody or in handcuffs. During the interview, the defendant gave consent for Detective Tangler to review different things on his cell phone. The defendant's cell phone was password protected. During the interview, the defendant entered the password to unlock his phone and provided it to Detective Tangler. Detective Tangler specifically requested permission, which the defendant freely gave, to explore maps, history, settings, and determine whether a Google account was attached. The defendant was present during that time that Detective Tangler was viewing his cell phone content. At no point did the defendant attempt to withdraw the consent he had given Detective Tangler. Later on during the interview, the defendant unlocked the phone a second time. This interaction between Detective Tangler and the defendant was consensual, and any information that Detective Tangler observed during this interaction was lawfully obtained. Seizure of cell phone.
So basically, they're saying he didn't ever ask for it back and he unlocked the phone, therefore, it was legal. So far, that's what they've said.
The defense heavily relies on United States versus Place in 1983 in support of their argument that the seizure of the defendant's phone was unconstitutional. In Place, the court was forced with whether the Fourth Amendment prohibits law enforcement from temporarily detaining personal property on the basis of reasonable suspicion. Law enforcement in Place detained the defendant's luggage for the purpose of a, quote, sniff test, unquote, by a trained narcotics detection dog. The dog was utilized approximately 90 minutes after the initial detention and alerted to the presence of narcotics. Law enforcement obtained a search warrant 3 days later. The court's analysis was based upon a seizure pursuant to reasonable suspicion. In determining whether the detention was permissible, the court must weigh the intrusiveness of a limited seizure of the individual against society's interest in detection and prevention of a crime.
So basically, like he said, in Place, which is what they cited several times. Ah, we lost you. Okay, so what they're saying basically is in Place, which the defense cited several times, the cops detained his luggage and then 90 minutes later had a dog search it with a sniff test because they had reasonable suspicion to believe there was narcotics in this man's luggage. And 3 days later, they got a search warrant, and they're saying basically you have to weigh what someone would think. Like if I hand my phone over to law enforcement and they ask to look at my Google account, am I going to reasonably believe that they're going to search my Google account? They're going to go through the pictures, through everything on my Google account. Oh no, we lost Jen again. I remember, there you are. We keep losing you.
We've got a storm cloud hanging over us, and when my phone switches from the Wi-Fi in the house to back to my phone, it does it.
Oh, okay.
It'll cause me to lose connection.
Okay. Well, I hope that the storm cloud goes away. I enjoy having you up here.
It's weird. It's sun shining right on top of the house, but you look at the house next door and it's black as soot.
Oh, you know what I was told when I was younger, and I've told the kids, I want to give you a trigger warning, but also I've always heard that if it rains while the sun is shining, then that means the devil's beating his wife. I don't
I've
know
heard
if
that
you've ever
too.
heard that.
And if it rains when a loved one passes away, it means the angels are rejoicing that they've made it through the gates of heaven.
Oh, really? See, I hadn't heard that, but like, I know that when, like, at certain times you can see the sun, like rays of the sun shining down on a certain area, and I've heard that that means somebody that just died is going to heaven.
There's a lot of them motels that are just interesting. A lot of them you just find it in your heart to just hold truth to it.
Mm-hmm. Yeah. She was telling this idea to Tyler when it had passed a few hours and Jen was already creating her evil story. I've seen that and kind of questioned that myself. If I had to guess, I would say that he was intimidated by Tyler. Tyler was a military man, and I mean, I'm assuming a no bullshit kind of person, so I think he was intimidated and put on a front, if I had to guess.
Was Tyler active in Madeline's life the
So
whole time?
Tyler had actually cheated on his wife Tatiana and met up with Jen while he was stationed somewhere, I think Georgia, and they had a one-night stand because they had been together when they were teenagers and dated for a while. So Jen was somewhere in Georgia or New York or something, and they met up with each other after not having seen each other in several years. They had a one-night stand, and Madeline was created. During that time period, he says Jen tried to basically mess up the relationship between him and Tatiana because he had cheated on Tatiana. They were supposed to get married, and now he's having a baby by this other woman. He wouldn't leave Tatiana, and Tatiana didn't leave him. She had the baby. He saw Madeline when she was younger, like a toddler, is what I've seen pictures from. Jen got full custody because mommy and daddy paid for it in court, from what I've heard, allegedly. And then Madeline flew back out there recently. I think it was the October before she passed away, to see him again. So I don't think he had seen her too many times.
So he was really never ever given an opportunity to.
Yeah, they talked on the phone and things, but I think he'd only seen her a couple of times, if I remember correctly from his interrogation, or where he speaks to police.
Unquote.
That's sad.
The court also
That's
identified
sad.
factors that the trial courts.
Sorry, love. Yeah, it is sad.
You're fine. I was just saying it was sad. Okay, I'm muting again.
Oh, you're good. He had a firearm in the bedroom next to the child. He'd be in SAN and taking videos and pics. Yeah, that was scary. I honestly, yeah, it's scary, but I don't think there's a correlation. I unfortunately think he had manipulated her enough to believe that they were in some type of relationship. I don't think he had to use the firearm to intimidate her. Stearns is early a menace, and the only reason there's no other victims is because he had one at home. My mama died. It was a light snow. Her street light in front of her house was the only one off. Oh, wow, Angela. I'm sorry that happened, but that's kind of sweet.
Should consider when making this determination. 1. The duration of the detention. 2. The intrusiveness or degree to which the person's possessory interests are interfered with. 3. The diligence with which officers pursued their investigation, seeking a warrant promptly and communicating with the suspect about the specifics of the detention. And 4. The government's interest or law enforcement purposes served by the detention. They cite United States versus Babcock from 2019. This is the analysis when the detention is based upon reasonable suspicion alone. The court in place also stated, quote, law enforcement authorities have probable cause to believe that a container holds contraband or evidence of a crime, but have not secured a warrant. The court has interpreted the amendment to permit seizure of the property pending issuance of a warrant to examine its contents if the exigencies of the circumstances demand it or some other recognized exception to the warrant requirement is present, unquote. They cite Arkansas versus Sanders from 1978, United States versus Chadwick from 1977, Coleridge versus New Hampshire from 1971. In the instant case, the item seized by law enforcement was the defendant's cell phone. The Supreme Court has interpreted the Fourth Amendment to allow a warrantless seizure when law enforcement can show both 1. Probable cause to believe that property contains contraband or evidence of a crime, and 2. Applicable warrant exception such as extingent circumstances exist. They cite.
So that answers my question from earlier, whereas I was talking about locked boxes in a trunk, if it's clear and you could see through it and there's a bloody knife on the inside, he's saying that they would have probable cause to search that without a warrant because they can see there's a bloody knife in it, right? Now they're citing this and extingent circumstances, and they're going to, in the next paragraph, relate it specifically to Stephen Stearns.
United States versus Babcock from 2019 and Jefferson versus State from 2023. Probable cause to seize the defendant's cell phone. The first prong in the analysis for the court to determine whether Detective Tangler had probable cause at the time that the defendant's cell phone was seized. The seizure of the cell phone occurred at approximately 8 p.m. on February 27, 2024. Probable cause, quote, merely requires that the facts available to the officer would warrant a person of reasonable caution in the belief that certain items may be useful as evidence of a crime. It does not demand any showing that such a belief is correct or more likely true than false. A practical, non-technical probability that incriminating evidence is involved is all that is required, unquote. They cite State versus Darter from 2022, Texas versus Brown from 1983. Probable cause only requires, quote, a substantial chance, unquote, that there is evidence of a criminal activity.
Joyous N just gifted 20 Speculation Station memberships. Thank you so very much. That was so sweet of you. Those went to Bree Ling, Short Arm of the Law. Sorry. Raven's Magic, Shebear, La Mela, I Plead the Fifth, Barb Murray, Lena Lee, Queen of Hearts, Cassia, Kelly Fields, Kelly Owen, I'm Free to Be Me, Moon Shadow 101, Jeff's Couch Pineapple, Jeanne Daughtry, Crazy Cat, Mia Mercy, Malibu Surf, Kathy Lou. Sorry, I don't know why I had such trouble saying those names. If you were gifted from Joyous and you are aware you were gifted, please tell Joyous thank you. And I want to tell you thank you too. That was so sweet of you. I really appreciate that. Thank you so much for the support. I'm going to grab the crazy train and pick y'all up on the way to Speculation Station. I'm going off the rails on a crazy train. Thank you so much, Joyous N. That was so sweet of you. Okay, so Jill said they can kick in a door if they hear screaming. Is it not the same kind of? Yeah, it is the same. But I don't know. It's hard to relate it because it's like, would you have found the pictures and videos had you not searched the Google account? Like, yeah, there is an extingent circumstances because Madeline is missing, but the phone didn't lead to you finding her. It was the tire witness. I don't know. We're going to continue listening and see what their argument is. Aw, thank you guys for saying thank you. Oh, yeah. Jen's interviews are so telling.
Illinois versus Gates from 1983. The courts have also found that a, quote, substantial chance exists where the facts within the collective knowledge of law enforcement officials suffice to cause a person of reasonable caution to believe that a criminal offense has been or is being committed, and that evidence of that offense will be found in a particular place, unquote. They cite Babcock and Gates versus Clocar from 2018. Detective Tangler and members of law enforcement have probable cause to believe that there was evidence of a crime contained in the defendant's phone at the time of the seizure. At the time of the seizure, the following information was known to law enforcement. 1. Madeline, a 13-year-old child, had been missing for over 24 hours.
Hey, if y'all don't mind, please hit the thumbs up. I was just looking at chat and I saw there was 26 thumbs up. So if y'all don't mind, please don't forget to hit the thumbs up. We are blessed in so many ways. We are, Boomer. Jingle, get the hammer. Oh, Lord.
2. The defendant was consistently identified as the last person to have seen Madeline prior to her disappearance. 3. Law enforcement had tag reader evidence that the defendant was not being truthful in regard to his movements on February 26, 2024, including when and where the defendant claimed to drop Madeline off at school. And number 4, Madeline never arrived at school on February 26, 2024. Number 5, the defendant factory reset his phone on February 26, 2024. 6, the defendant was alone with Madeline in a bedroom prior to the night of Madeline's disappearance. 7, the defendant regularly utilized his cell phone to speak with Madeline. 8, the defendant, when confronted with inconsistencies which evolved in his statements, began adding additional explanations. 9, the defendant had a cell phone with him during a portion of the day on February 26, 2024. 10, the defendant regularly used the location data and internet on his phone. And 11, the defendant's phone was attached to the defendant's Google account, even though the defendant denied being logged in.
So, did you guys understand everything that they're saying, or do you want me to go back through and talk about each one specifically? I can do that if I might need to do that myself. Let's just do that. Let me talk about each thing specifically. We're at 4304. Go back to 4251. Nope. Try that. Okay, I'm backing it up so we can talk about each thing specifically.
cause to believe that there was evidence of a crime contained in the defendant's phone at the time of the seizure. At the time of the seizure, the following information was known to law enforcement. 1. Madeline, a 13-year-old child, had been missing for over 24 hours.
Okay, Madeline had been missing for over 24 hours. Therefore, you're going to ask for everybody's phone that is related to the child, or, you know, that lives in the household, that's around them, all of that. You're going to want to search all that, trying to find this missing child and the child's cell phone. I mean, that's just a given.
2. The defendant was considered.
Do what now?
Check it off. Extingent circumstance. Ka-ching. Next.
Yeah. Yep.
Consistently identified as the last person to have seen Madeline prior to her disappearance.
So you're obviously going to check the phone of the last person to see the child. He was the last one that had been verified to be with her, and she had went missing after that. So you're obviously going to want to know his whereabouts, his phone location, all of that.
3. Law enforcement had tag reader evidence that the defendant was not being truthful in regard to his movements on February 26, 2024, including when and where the defendant claimed to drop Madeline off at school. And number 4, Madeline.
Okay, so he had said, I dropped Madeline off on Hunters Park Lane so that she could walk to school. Well, by this time, they had checked the traffic cameras because they're trying to locate this missing child, and they saw that he did not drop her off where he said he dropped her off at. So they're proving that he's lying, and he was the last person with her. So that's suspicious AF. Yeah, Jen couldn't remember the last time she saw Maddie or remember what she was wearing. Absolutely. Mega Moshi, good to see you. I don't know if she ever expected to be able to have a proper relationship given they would have no privacy, as Madeline was always in her bed and the roommates were in the house. That's a good point. Yeah. I got to get in that garden. She never cared about Maddie, so she never expected anything because she didn't even try at all. Maddie was a burden and a drag to her. It sure seems that way. All right, continuing on.
Madeline never arrived at school on February 26, 2024.
So again, Stephen was the last person with her. Stephen was lying about where he dropped her off, and she never made it to school, and she's missing.
Number 5, the defendant factory reset his phone on February 26, 2024.
So he factory reset his phone on the same day this child goes missing, on the same day that he's lying about where he dropped her off, and on the same day that he was the last person with her.
6, the defendant was alone with Madeline in a bedroom prior to the night of Madeline's disappearance.
So that's suspicious AF too, even if Jen said that it was normal. Jen could have looked on the bathroom or bedroom floor to see what she was wearing the night before. Good point. All right.
7, the defendant regularly utilized his cell phone to speak with Madeline.
So he's constantly using his phone to talk to Madeline. I don't know if that... I'm assuming like he talked to her several times a day, every day. So they're looking at... or they look at her phone, and he hasn't even tried to contact her on the day that she went missing, and she's missing, and he's lying about where he's dropped her off at, and he's the last one with her, and they slept in the room together the night before, I suppose, would be...
This fool's just looking for sympathy on the court to get out of, to keep from being held accountable. There's too many extingent circumstances here for them to have any grounds of suppression at this point.
Yep, I agree. I hope that the court does. Nath, thank you for gifting a Speculation Station membership. That was so sweet and supportive of you. That went to Inquiring Mind. Inquiring Mind, if you are here and you are aware that Nath gifted you a membership, please tell them thank you. And I'll grab the crazy train to pick you up on the way to Speculation Station. Thank you so much, Nath. I'm going off the rails on a crazy train. I really appreciate that, Nath. That was so very sweet of you. Thank you so much. Yep, good points. Detective Tangler and Acosta were looking for a missing child. At that point, that was priority. Right. You know, Miss Kimmy, I do think that Jen saw Maddie as competition and an enemy. Um, and that concerns me. I mean, I certainly hope that I'm wrong, but that's what it seems like to me.
8, the defendant, when confronted with inconsistencies which evolved in his statements, began adding additional explanations.
Okay, so that's like, you're not on the traffic camera where you said you were. Why weren't you there at this point in time? And then he's like, oh, I forgot to tell you, I came back to get the gate clicker because I forgot the gate clicker. Like, his story is inconsistent, and they're pointing that out.
9, the defendant had a cell phone with him during a portion of the day on February 26, 2024. 10,
so he had it with him during a short period of time, and he normally has the phone with him, but he didn't have the phone with him when he dropped the child off to school, and he's the last one that was with her, and he was lying about where he dropped her off, and she left her phone at home too. I mean, all these things look sus AF, right?
I still say he left both them phones at that house so Jennifer would reset them.
That's an interesting theory. Do you think that, like, he did it so that obviously they wouldn't track the phone or be able to get any information of where he actually drove, and in hopes that Jennifer would reset it at the same time?
Yep, I do. Because you look at the time frames on whenever he was seen on those security cameras, and then you look at the time frames when he was pulled up to the trash bin and unloaded all of that stuff, and then you look at the time that he pulled through the gate and the time that Jennifer was at home, and then when he come back saying he went to the smoke shop. Mm-mm. That man left them phones there at that house on purpose for Jennifer to reset and wipe them clean.
I think that's a good theory, yeah.
That's why, and I think that's why she knew so much, pretended that. Wait a minute, let me back up. And I think that's why she responded the way that she did about let him check your phone, because she knew that she was just as confident as he was that they wasn't gonna find nothing.
Yep. I think so too, and I'm wondering how all of this was going on. And there was nothing on her phone. Like, was she able to actually reset her phone? I wonder. We're gonna after this, we're gonna look at how they obtained Madeline's phone and search through that too, to kind of try to figure out some of that.
I mean,
You think Soto made him do it? Interesting. I honestly, I thought that was a possibility, but then we found out through Hio that Madeline was laid in the prone position, and that really upset me. I thought that he was going back out there because he really didn't mean to commit the homicide, and he was crying or doing whatever, but then we find out that she's basically, like the Ludacris song says, face down, butt up, and then he's got that masturbation cream in his book bag, and I'm like, yeah, what exactly were you doing out there, sir? How did Stearns
the
get...
autopsy report.
Well, we haven't seen it yet, but we will when we go to court. How did Stearns get into the condo that Sunday night if he had moved out months prior, and if the door is locked and Maddie's in the shower, roommates were out? That's a good question. Because he had the gate clicker still. And we do know that there was DNA on her chest. Yeah. That was like a DNA report, but yeah, they did give us that, which is... Ugh.
The defendant regularly used the location data and internet on his phone, and 11.
So he regularly used his Google Maps and location data on his phone, and he didn't that day during the time period that Madeline went missing, and he was lying about his whereabouts.
The defendant's phone was attached to the defendant's Google account, even though the defendant denied being logged in.
So he was logged into his Google account, and it was attached even though he said he wasn't. So he lied about being logged into the Google account. He said he wasn't, and he in fact was. I think Jen Soto told him where to take the body, but Stephen didn't take her to where Jen Soto told him to, as into the gator and swamp. I've thought about that. They would be able to find out if Jen... I would think so, but there was nothing on her phone. I don't know. crazy to me that all this was happening and nothing was on her phone. But, you know, it could be true.
Collectively, these circumstances gave law enforcement probable cause to believe that the defendant had committed a crime against Meline and that the evidence of the crime would be found in the defendant's cell phone. Extingent circumstances. The 4th District Court of Appeal in State versus Daughter from 2002 cited to the Supreme Court when considering extingent circumstances, quote, the test of whether extingent circumstances exist is an objective one. They cite United States versus Chohan from 1991, quote, whether extingent circumstances exist in a given case is a fact-specific inquiry that depends on the totality of the circumstances. They cite United States versus Ariello Ocha from 2006 and citing United States versus Banks from 2003. Quote, when considering the extingent circumstances of imminent destruction of evidence, the objective test applied by the court is as follows, quote, the government must show more than a subjective fear of imminent destruction of evidence. The fear must be objectively reasonable. In determining whether the agents reasonably feared imminent destruction of the evidence, the appropriate inquiry whether the facts as they appeared at the moment of entry would lead a reasonable, experienced agent to believe that evidence might be destroyed before a warrant could be secured. In other words, quote, were the police unreasonable in not getting a warrant in the circumstances that confronted them, unquote. They cite Darter and Gilbert versus Stake from 2001, quoting United.
So basically they're saying, is it unreasonable to pull his cell phone and want to search through it without a search warrant, considering the fact that he lied about where he was at. He was the last one with Maddie. He talked to her regularly. She's missing. He's lying about his whereabouts. He's lying about his phone. He's lying about this, lying about the third. He factory reset his phone on the day the child went missing. Is it unreasonable to want to search his phone and not necessarily get a search warrant? That's the question they posed, and they're citing these cases afterwards. Barb Murray, I'm not sure. I'm wondering if that's coming down the line.
United States versus Riviera from 1987. Courts have found that extingent circumstances exception, quote, particularly compelling in cases dealing with electronic files. They cite Babcock and United States versus Bradley from 2011. In Bradley, the court found extingent circumstances permitting law enforcement to shut down servers in order to prevent employees from destroying evidence. Detective Tangler, along with other detectives of the Orange County Sheriff's Office, had an objective fear of the imminent destruction of evidence contained on the defendant's phone. The defendant had been evasive and deceptive in law enforcement interviews and was untruthful regarding his whereabouts the morning of Madeline's disappearance. The defendant had already attempted to destroy evidence contained on the cell phone by factory resetting the phone at some point during the late morning hours of February 26, 2024. Although the cell phone had been factory reset, there were still extingent circumstances supported by an objective fear of further destruction of evidence by the defendant. The defendant was also...
So he had already tried to factory reset his phone not once but twice. What if he was successful? I think it's absolutely valid to have a fear that he's going to destroy evidence. Rose Shields, thank you so very much for the super sticker. That was so sweet of you. Thank you for the support. For some reason, it's not loading my chat on my phone. There it is. Oh, it says #1 fan. That's so sweet. Thank you. I love y'all so much. I love our speculating family. Oh, Bad Girl said that you can have book smarts, but that doesn't mean you have common sense. And I wanted to do this for you. That's absolutely correct, Bad Girl.
Boom, 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 bop, bam.
You absolutely can. Being book smart does not mean you have common sense. Absolutely.
Also aware that law enforcement was interested in determining the Google account associated with the phone. The defendant was aware at that point that law enforcement had evidence that contradicted his claimed movements on February 26, 2024. It is reasonable to believe that the defendant knew he was under suspicion once Detective Tangler and Detective Acosta confronted him with inconsistencies and showed interest in the information contained on the cell phone. It is
So therefore, when he knew that they were asking him questions about the phone and the Google accounts and the specific things, they also confronted him by saying, okay, you told us you were, for example, on 1st Street at 10 a.m., but we have your car over here on 7th Street at 10 a.m. So you're lying to us. Why are you lying to us? And he still had possession of the phone. Is it not reasonable to think that if we don't go ahead and get the phone at that time, he's going to further try to destroy the evidence? And that would go more into, okay, he's done 2 factory resets already. What if he had been successful, or he figured out that he wasn't successful in doing the factory reset? So what's to say he's not going to throw his phone in the river, run it over with a car, hit it with a hammer, all of those type of things. Meemaw, thank you so much for being a member for 2 months. That is so amazing. Thank you so much for your support. Meemaw said, yeah, for me. Right? Blue Sapphire said, I would like to ask each policeman and investigator who heard the words, yeah, she sleeps with me when her mom doesn't wants to sleep and disturbed, and sometimes we all sleep together. The cop actually was, you could tell by his demeanor, he was a little concerned about that. And then you get the whole Woody Allen situation comment. I don't know if they did. I don't think so, Barb, but it is a life and death situation.
It is also reasonable to conclude that the defendant had the ability and incentive after the interview with Detective Tangler and Detective Acosta on February 27th, 2024 to further destroy incriminating evidence contained on his phone. Conclusion. Law enforcement legally seized the defendant's phone on February 27th, 2024 after developing probable cause that there was evidence of criminal activity contained on the defendant's cell phone, and extingent circumstances existed that the defendant would further attempt to destroy evidence on the cell phone. Therefore, the defendant's motion seeking to suppress evidence recovered from the seizure of the cell phone should be denied.
So, again, there was probable cause to believe there was evidence of his criminal activity contained on the cell phone, and Madeline was missing. They were trying to locate Madeline. They proved that he was lying about where he was at. They proved that he had already factory reset his phone because he told them he had. On the day that Madeline went missing, there was plenty of reason to believe there was evidence on that phone and that he was trying to destroy it. So therefore, they're saying they're completely valid in their attempt to seize the cell phone. Now we're going to jump over to the body cam footage and see how they asked for Madeline's phone, how they obtained it and looked through it. So let's find that. I think it's way back here. There we go. All right. So we're going to take this back to the beginning. A lot of reasons to kick in the door. Yep. Oh, Genevieve, I saw that you dropped. I'm sorry. I just now saw you back there. I don't know how long you've been back there.
I had to take an important call, and it dropped when it rang in.
Oh, okay. Well, I'm glad you got your call. She was off shift. Why it took so long, I don't know why they don't just say it. I don't quite understand, Julie. And it's good to see you. Okay, so we're going to go over the body cam footage and see how they asked for Madeline's cell phone, how they obtained it, and how they went through it. And relate it to what we've heard of them obtaining Stefan's cell phone. Oh, yeah, there's no volume right here.
And their house is pea soup green? That's sus.
Yeah. That is sus, like, yeah, but I don't know that they have they own the condo, so I suppose they could paint it, but I think all of those condos in that area, no, hers is blue, I guess. I don't know. There's a bunch over there that are that color. I think, okay, about the locks on the door, to be honest with you, I think that all of the rooms had locks on them. I think did go back through those pictures and saw that all of the rooms did have locks on them, probably because she was renting the rooms out and people want privacy, so they lock their doors. I think they did love to hunt. Good question.
Hello.
Hi.
Are you Madeline's mom?
No.
No. Are you Madeline's mom?
Yes.
Did she come home?
What's that?
Did she come home? No, you don't.
So that's suspicious to me, and I know that's not what we're looking at right now. But when we look at the body cam footage of the sister's first question is, "Have you found Madeline?" That's not her first question. The cop has to ask her if Madeline came home. Like, in my opinion, it's because she already knew that Madeline wasn't coming home. Why do they have to ask you, "Has your child come home?" Why aren't you asking them, "Have you found her?"
Right.
Detective Tangler said she was going off shift after she had spoken to him. She went home, so couldn't do anything with the phone. Oh, that's a good point. For the 9.5 hours. But I mean, another detective should have taken over, got the search warrant, and done the download. But I get what you're saying, absolutely.
I don't know where she would have gone. No. Did she take anything? Any clothes?
Her birthday money is still here. Toothbrush, everything.
Okay. So nothing that she like took with her and went somewhere else. Is there any place that you guys think that she would have went? Any friends' houses?
The only friend I could have thought was, but I think Orange County PD already went to her house and talked to them.
Okay. What's that address? Just so I can make sure they already checked there. So they're trying to look everywhere they can.
Of course.
First name is.
Let's see if I still have Google Maps pulled up to her address. Let's see.
You know, another thing I just noticed is how she's like shutting down every possibility, right? Like they say, have you, is there a possibility she could be at a friend's house? And she's like, immediately, no, the only friend I know is this person, and the cops have already been there. Like, I would assume you would be like, well, the only friend I know is this person, and the cops have already been there, but you could check that person again. Maybe she's got a friend at school that I don't know about, that maybe she's met somebody around the like apartment complex or whatever that I don't know about. Like, she could be at any number of friends' house. Let's, check all these places. Have you checked this place? But she's like shutting them down. Like, they're asking her, is there a possibility she could be here, here, or here? And Jen's automatically like, no, this is why.
Well, even Stephen, he bebopped his skunky ass up there to intervene. They're there to talk to her mother, not him.
Yeah.
So he has to interject.
Mm-hmm. Yep, and the way he stands over her looking at that phone, I mean, it just points out his guilt, in my opinion.
And then the sister's in the background. She's got crap rolling through her head. She's got 1,000,001 things going through her head right now.
Mm-hmm.
And she's groomed and conditioned like everybody else in society. Let the cops do their job. Been there, seen it I'm not saying a million times, but I've seen it a lot. You've got legitimate people who are absolutely concerned for a missing child, and at this point, the sister only thinks that her niece is missing. She may have her suspicions of other things, but look where they're at. Look at their location. It's a hub. It's a hub in itself. So there's 1,000,001 things going through these people's minds.
Yep. I agree. I know, Meemaw. It's sad to think about him standing over Maddie. Like that.
Did she go to school today?
No.
No. Okay.
She was supposed to. She was dropped off close to school. She wanted to walk. the rest of the way because she was embarrassed by his car.
Okay.
Which is normal for her to ask to be.
It's an image thing.
Right.
But she never made it.
Right there, I'm not, I know we're looking for the cell phone thing, but even right there, it's not normal for him to drop her up at school, but she's making sure to reiterate that it's normal and that it's an image thing, and she stutters and pauses afterwards because she knows it's not normal, in my opinion.
I went to the school to pick her up at the end of the day, and she never came outside. I drove away thinking maybe she walked to my mom's office because sometimes she'll do that if I can't pick her up. And my mom's office is less than, what would you say, half a mile away?
Yeah.
It's pretty close.
Something like that.
She would get there, school ends at 4:04, she would get there by 4:35 the latest. She never got there by 4:35. I started driving around. I went back to the school was closed.
Most of screamed she could maybe walk to her grandma's house, but that's a lot further.
When the school was closed, I realized something was wrong. I called and I said, "Hey, did you see Maddie today? Or is she with you? Because I can't find her." And she said, "No, she never made it to first or second period." And I said, "What do you mean? I dropped her off at school." And she's like, "She never made it to school." And I said, "Can you please check with the rest of your friends, see if she made it to any of her other periods?" At this point, I messaged her teachers directly, and I asked if any of them saw her. 2 of them responded to me. One of them told me she didn't make it to his period, and
Now, I only know of one responded, and that was the creepy chorus teacher that just got in trouble.
he also checked her attendance for the rest of the day. She never made it to any of her periods. This is when I knew something was truly wrong because she was dropped off by him close to the school. She should have made it to school. At that point, that's when I called 911. This was around 4:35, 4:40. Police did not show up till 7:30, I want to say.
Up in Orange County?
Up in Orange County.
Okay.
And then at that point, that's when all the questions started happening. And then he took them to where he dropped her off. Someone in an outfit she was wearing sit in their parking lot for a little bit, like take a break from her walk, because she was early for school, and then get up and then leave towards the school. That's as far as I know.
Okay.
But yeah.
Okay. Were you able to find his address?
Sorry.
No, you're fine. I know you guys got a lot going on. Did she?
So, again, it stands out to me how rehearsed it sounds. Even that's when I knew something was truly wrong. I don't know.
How many phone calls was made between 4:30 when she made the initial call that Madeline was missing up until the first time that law enforcement responded? You know, if my kid was missing and they hadn't showed up yet, I'd be speed dialing. So how many calls were actually put in to Orange County 911 and wanting to know what time they were going to show up that their child was missing?
So there was 3 calls made total, and I think they're about an hour apart. One of them's 30 minutes or so, and I think the other one's about an hour. So yeah, I would think that, I mean, I would have, the urgency of my child being missing, I probably, judging by how I know myself, I would have called probably back to back. Like, I would be given like maybe 5 or 10 minutes for them to get here, and then I would be like, "Where are you at? Why aren't you here? Where are you at? Why aren't you here?" That's suspicious to me too.
Or or at least added in information like my sister's over on North Parkway in that area. My boyfriend's over on South Parkway in that area. You know, I would have been notifying the police department that, hey, I've got people out here searching in case you run into one another trying to get here. We're searching for my child. What's taking you so long?
Right. Exactly.
Yeah, these fools knew what they had done. These fools knew they were doing everything they could to cover up, thinking everybody else was dumb in the process.
Yep. Everybody had believed their stories their whole lives pretty much, and so they just thought everybody else would believe it too, in my opinion. Yep. Rhonda, I agree.
Take her school laptop with her?
She did.
She did.
They already tried to track it, but unfortunately the unit is completely powered off.
Oh,
It's
okay.
completely offline according to them. They were unable to do anything with it.
Okay. She doesn't have any other kind of technology that you guys could track. I'm sure you guys already
No
checked
text,
that.
no nothing.
She
Normally
accidentally,
she has her phone, but she left it at home, didn't it?
and that is normal for her. She's got ADHD. She's very forgetful.
Okay.
That is not normal when you've got a boyfriend calling and texting you throughout the day while you're at school with what he said in that interview.
Oh, you're talking about the fact that there was a lot of communication with Madeline, and the friends say that he would text her and call her while she was at school and talk to her. Is that what you're referencing?
Yeah, and then the day she goes missing, oh, she just left her phone at home. We left our
Yeah,
phones at home. That's bullcrap.
it is. Yep, and the detectives called her on it too in the only video recording we have so far of her. I think there's proof of that because she corrects him, references the shorts, and he goes along with it from then on and says shorts in the interrogation despite him being correct about pants. Wait a minute, what did Lori say? Did those two sleep in those clothes? Oh, maybe. I think it would be hard to dress a deceased body in a pair of jeans, so I don't know.
I believe. No, this is CSAM.
How you spell that? Let me see that. Gotcha. And what's a good phone number for if you guys have one?
Yeah. Should have.
Look at him looking over at the damn phone. Like, he's legitimately leaning over to look at the phone. It's ridiculous.
Okay, no other family in the area except for
Grandma.
grandma.
The existing family already up at the office and met with the cops.
Yeah.
The only other closest family member is my sister. She lives in the next neighborhood over. If you were to exit the back gate.
Next door, right over here?
Yeah.
Okay.
So if you exit the back gate, the first neighborhood to your left, at East
Yeah.
Hill Plantation. She lives in there.
The office too.
Okay.
But yeah, she was in the office helping me with the police, and she was the one who actually went through her phone and her messages and was trying to see if there was anything weird.
Yeah.
We didn't see anything too weird.
Nothing weird. You guys haven't had any recent arguments?
Recently, no. Apparently, on February 2nd, she sent a few messages to a friend stating that she would run away. But it must have been after. From the messages, we must have been arguing, or I must have said something that upset her because she was very upset in her texting with her friend. But
do you guys still have those, or no?
yeah.
Okay, so far, the way he asked for Madeline's phone is she referenced messages about Madeline wanting to run away, and he said, do you still have those? She's signaling the police. Oh, Freudian slip by pointing at Stefan? Possible. Yeah.
And that's her phone?
This is her phone.
Oh.
I don't know why it's holding her. It's wet.
Oh, here, let me log into my daughter's phone so you can see what I haven't done.
Yeah. Yep. And he's hovering over her looking at the phone. He verifies that it's Madeline's phone, but he hasn't asked specifically for it yet.
And she conveniently leaves the messages from all the way back to February 2nd, possibly deleting anything from February the 3rd forward.
Yeah. I don't know.
She didn't want to.
Yeah.
She didn't want to make it seem too suspicious with a child's phone.
I'm sorry, you said she didn't want to make it seem too suspicious with the child gone? Is that what you said?
With a child's phone. Because she's a
Oh, yeah.
teenager, activity on the phone. She didn't want to make it look like she had been in her phone.
Yeah. I'm wondering how far back the messages go. He might say it in this interview, but I don't remember. That's a good point. She will rot in hell if she really did know. I think it
she's
was her
living in
mom.
her own hell.
I do too. Sweet Bee. Oh, I don't see. See, I hate sometimes I don't get to see messages. Hey, Sweet Bee. Hey, Rebecca. You're good. You got here right when you're supposed to be here. Yeah, it's her mom and her stepsister, I do believe, that called.
Do you remember who
starts with an S?
No, I'm just trying to see. It's
That's what it was, right? Second.
yeah, this is Savannah. Okay, this is her. See, I don't recall getting in a fight and saying this to her, but sure, we'll say that. I know.
Okay.
I mean, I taught her.
It's okay if I swipe down?
Yeah.
Okay.
So he just asked, is it okay if I scroll down, asking permission to even touch the phone? Bye, Teresa. Have a good day. Oh, okay. If she's jealous of Maddie, she may be mad at Stefan as well. Yeah, possibly. It's amazing to me that Stefan knew the information about wearing her phone. She had talked to the Sprint about running away, but maybe they discussed it and he was with her when they went through the phone with the sister. I don't know.
I don't know if you noticed it or not, but on most phones, when you're going through text messages, like if me or you were texting one another, on one side of the phone it would have your profile for your, for your little contact icon, and then it had your message, and then on the other side it would have my response with mine. Have you
Yep.
noticed as he's scrolling on this phone, it's all on one side of the phone?
Yeah, and it appears to be her talking. Now, right now, we can see these words in black that are her responding. Maybe that's the way it is on an iPhone, where everything you say is in blue and then the person you're talking to is in black. But I do find that weird because on my phone, it tells me who I'm talking to.
And on some phones, I think you can actually change the colors on the bubble.
Yeah, sometimes you can.
Where did she say that she wanted to run away? Did I just miss it?
Something that she can't wait till she's 13 and she's out of here.
Actually, I'm not sure where. I thought it was part of that conversation. Never mind.
But you claim to have just seen it because your sister pulled it up?
Right.
It was her cousin telling
Do you guys remember what she said? Did she say she wanted to
The gist
run
of
away?
it was she was mad at her mom and she can't wait turn 13 and like she was really
Run away to the woods. That's what she said.
What we could try and do,
That was the gist of it.
search. If you remember what she said, you could try and type that in and out. So she said run away to the woods.
Did she have any friends that had the last name Woods?
No.
No, but this was debunked because the only thing they ever found was that basically she was going to run away to the woods, but that was supposed to be if there was some kind of World War III situation, not because she was mad at her mom necessarily. Which is weird.
Let's see. We're talking about growing up and living in the woods. But that's not it. Okay, let's try running away.
Yeah.
Nothing away.
What about just run?
Run.
Jump. Run away?
No. Let me try it as one word. No. Let me ask my sister who actually went through her phone.
Okay. Do you have a recent picture of it?
Yeah, I can give you a few.
You can airdrop it to you if you like.
No, I just wanted to see it just so I know who I'm looking for. I know Orange County, they already have pictures.
We made these posters if you want them. This is what you're looking for.
Okay. Would you be able to text that to my phone? Which one is the best recent picture?
Okay, so as of right now, he's asking them to text the picture to the phone and not asking for the phone. Hey, Florida girl. Florida girl said, remember how Stephen Stearns told his mom that after he found Maddie cold and beyond coming back that he was in a total mental breakdown from then on. Look at him here. That's a good point. It's not because they're trying. Yeah, no doubt, Blue Sapphire. Abella said, my cat lost her way home once. I looked everywhere for a week and we found her safe at our neighbor's house that looked like ours, but I was completely freaked out. This fool does nothing. Yep, you're right.
The most recent was this one.
Okay. Do you wanna?
They're all very much her.
Okay.
That was a good point about the schools.
About the schools.
Yeah, what the comment made about how the schools don't do anything. Do you remember about the time that Madeline went missing? There was another little girl that was supposed to have got on a school bus. Somebody actually had taken her, and they found her deceased in Florida about the same time.
Yeah.
Okay. You know, there was a little group of people that was trying to get something passed in the state of Florida, get something in the form of a petition that would hold schools accountable for on a contingency for missing children. I'm just wondering if anything has came of that because that's over a year ago and I haven't heard anything on it yet. But I do agree there needs to be an enforcement of a contingency plan for our school system straight across the board in every state. If they don't show up by a certain time and they do roll call, they need to be getting on that call list wanting to know why those kids are not there.
Yeah. Yeah. A lot of this stuff could have been handled way beforehand if we talked about that in earlier streams. I wish that they would, in public school, they would have everybody do a roll call right when after they get done eating breakfast and right when they get to that first class, and then have someone immediately take it to the office so the office can start going through who's not there and making phone calls. That would solve a lot of this. As far as kids being missing.
They've got school resource officers. You've already got law enforcement on the scene. And it's already a 2 to 3 hour gap if the kid does go missing before they show up for school. So there's no reason why they shouldn't enforce a contingent.
Yeah, I agree. Yeah, that's another good point, Rhonda. They didn't invite them in if it's so cold. Why not invite them in? And when the dogs are searching, they're steady outside. They won't even go inside so the dogs can search. So, uh, yeah, great points. Referencing if he's so cold and hungry and taking an Ativan and couldn't get inside the warm car, he wasn't in his right mind. But here he can't stay inside. He's always out.
So
It's redacted.
Hey. Yes, I'm currently with Kissimmee PD. They came to the house real quick, and they're asking me about the text message where she said she wanted to run away to the woods. Do you remember who she texted that to and like what day, so I can show them that? Well, see, when I went to what I thought Tall Goblin, February 2nd, where she said, what did she say? Where she talked about like me acting up and that she don't want to live with me, or that I said something about kicking her out before she turned 18, or when she turned 18. It doesn't say it. It doesn't talk about her running away into the woods.
So Julie said that Hunters Creek Elementary does do. Okay, here they do that at Hunters Creek Elementary School. As soon as first period starts, the parents have already been notified. That's good. We need to do it at all the schools, but that would have been the elementary school she went to if she was living in that condo. And if they're not there by roll call, parents haven't called in, they're notified. That's good. A lot of this stuff, as far as children being kidnapped or hurt by somebody else, can be handled immediately when things like that are done. So that all of those are great ideas.
Well, didn't Maddie confide one of the school counselors of some things that were going on? Why didn't that school counselor look at the roll call? You know, they should be held accountable too. If a child goes to a counselor to address something, they're supposed to keep a file on this. So by
Yeah,
that time that first period roll call came through, that counselor should have been on the phone. But what's to say they didn't call Jen? What's
yeah,
to say that Jen did not get a call?
yeah. I don't know that. I mean, I guess the police would be able to verify if she did. Yeah, I don't know. I don't know if that would be necessarily the counselor's job either, to be notified every time one of their students was missing, but it's still a good point.
Yeah, I mean, again, what's to say that Jennifer was not notified that Madeline's at school? Is she sick? Oh yeah, I was meaning to call you. She's sick today. What's to say that that call wasn't made or that call was ignored and they just haven't utilized to check the call logs from the school?
Yeah, I don't know. I don't, yeah, I would think they would have it from her phone if she was called, but like she said that the bestie said that she texted Maddie and asked her where she was at or something to that effect. And Jen picks up Madeline's phone and doesn't even reference Bestie texting and asking where she's at. She says she called Bestie and Bestie said she wasn't at school all day. So she picked up the phone and looked at the text messages. She would have seen Bestie messaging asking where Madeline was at that day.
They
So,
cover up.
yeah,
Cover up.
in my opinion,
I think
yeah.
they're I think they're waiting on what they're dealing with the CSAM, and I think they're still putting everything together for the murder trial. And I'm not going to be a bit shocked if they don't have an indictment for Miss Jennifer in the process, and she's going to be tried separately.
I hope so. I don't know.
Say what?
Where did she say that? Did she ever say that?
In front of Home Depot. And log out Florida tag for me as well. That one. It'll be 0028 Alpha Yankee. Florida tag. It'll be a white minivan.
Oh, okay. 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 I'll let him know.
Apologies.
No,
Do
that
you
was
mind
it.
if I wait for a minute?
Okay. So what she had said was to Sage, actually this is Sage's dad that reiterated this to us, was that once she had said she wanted, wouldn't it be fun to go camping in the woods and do a bonfire? So that's what she mentioned about being in the woods. Not that she wanted to run away and live in the woods. Yeah, that's not running away.
And then with her text, pull up her text again. Have you guys checked her recently deleted text?
I don't know how to do that.
So
Teach me, please.
go back, I believe, edit, show recently deleted. So 6 days, 6 days, and 10. And you could just click on whatever and you can click recover and look through whatever they are. Those are all 6 days ago. I don't know if you want to.
Yeah, I mean, if I do that, is it going to get lost in the mix with her other messages, or is it going to show me individual like?
So right now he's trying to look at deleted messages and he's telling her how to do it. Hasn't taken the phone, hasn't asked for the phone. He's showing her how to do it and she's doing it in her hand. So that's what we originally started watching this for, was to see how he obtains Madeline's cell phone. I believe it's in this interview.
Well, something else I just thought of. You can have a contact saved in your phone, but you can block that person from calling and sending you text messages. How many of those contacts in Maddie's phone did she block, leaving the contact information in the phone? So because you know her friends are going to constantly keep trying to call another kid's phone if they think something's going on, not realizing that what's really going on with the phone, not knowing that mom's got phone. If Maddie's missing and they don't have that information, her friends are going to keep calling her phone, hoping that she will answer. So how many of those people, how many of those kids did Madeline talk to on a daily basis that Jen went in and blocked them, leaving their contact information in the phone?
I don't know. I don't see. Okay, as soon as Bestie got out of school, like 4:45 when she was getting off the bus, Jen calls and asks, has she seen Madeline at school? Bestie says no, and basically Bestie finds out that she's missing. So the only time period that would have probably happened would have been during school hours, and at that point her friends probably would have thought she was just at home sick, because by the time she's absent the second day, the cops are at the school talking to them, and Bestie has probably notified them that she's missing. So I don't know how many would have called, because during the initial period they might would have thought she was homesick, and then by the time they find out that she's missing, there's no reason to call the phone. You know what I mean?
Well, I get that too, but I'm thinking on a preteen teenager mind frame here.
Yeah. I mean, it's a possible speculation.
I'm not sure.
I probably just shuffle it back into the list of messages.
Let's try this one because we don't know who this person is.
Okay.
Yeah, try that one. Click recover.
Recover message.
So then go back. You just click done. And then.
Maybe you don't recognize?
That's at 6 days ago. It's not there. What was 6 days ago? What day of the week? This one? That's more than.
Drone 2 Baker 30 in check.
No. No, too much stuff.
Okay.
You know, just a speculation here. I don't know that they were ever able to recover that one that said 6 days ago, but she said we don't know who this contact is. His voice gets real low and kind of worried, and I think that that's the message that I've always been curious about, that they couldn't find even in recovering deleted messages. I wonder if that's Stefan, like
I'm
another
wondering if
name
it's
for.
Stefan too.
Yeah, like I'm sure she has Stefan in her phone, but I'm wondering if that's like a nickname they made to each other so they could talk to each other kind of privately, and there's something deleted that still wasn't able to be obtained. Um,
Or it's a say second phone number.
yeah, that's interesting. I never thought about that until now.
It's so weird.
Go ahead.
I think this was the number. I'm not too sure.
I think it was too.
But it was
I
just.
think it looked like it, but it said that there was only one
They saw
message.
that there was a 7 in it, so.
No. So I don't know.
Who's the other one? Tall Goblin? This one?
Yeah.
Or was it the one with the S? Door.
It does, Boomer.
Oh, so that's Tall Goblins with the S. So one was Friday.
Is that a group chat? That does seem like a group chat, yeah.
Yeah.
She went to a lot of group chats, I think. Especially when she was gaming.
So when 6 days ago.
You see, they just mentioned a lot of group chats.
Yeah, she was in a lot of group chats, they say, which is weird to me. I'm not in any group chats. That is weird to me. Groomers make children believe it's their secret, and it went on from when Maddie was 6 or 7, so it was normal for her to keep secrets. Not sure about the rest of the family. Yeah, that's more than likely true and very sad. Yeah, that's true, Rhonda.
6 days ago, what was it?
So just goofy shit.
The 21st.
Wait a minute.
Yeah.
Just goofy shit.
The 21st.
Why is that blocked out and the rest of the phone isn't?
Yeah.
Because it's showing images.
19.
Yeah, but it was showing other images, and I wonder what that was a specific image of. Because it showed several images. I was trying to see what it was.
19.
Yeah, you're probably right. That's probably what Jen was trying to tell me, and I wasn't understanding. It's probably what Jen was saying, and I wasn't understanding. Yeah, that's probably what it was. A photo of a child or image of a child.
Wednesday. So we'll look between Wednesday and the 20th. Wednesday.
Have y'all noticed how quiet that neighborhood is?
Yeah, it is quiet.
For an
Is it?
apartment complex filled with children, there's no doors, there's no lights on in the other condos. the only thing burning is a porch light, a street lamp, and then the landscaping lights in the background. That's a super quiet neighborhood.
Yeah, I'm wondering because it says 26 minutes if it's 12:26 in the morning, but it's very quiet regardless. You're right.
No, it's 20th. I don't see anything in there.
She mostly stuff for gaming and stuff.
Yeah. Okay.
That's all she uses it for.
Yeah. I know the other officer already came here and looked inside, right?
Yeah.
Do you guys mind if I go back in and walk through with you guys?
Go for it. Come on.
You guys want to show me the way?
Okay, that's where they're inside. Okay, we're going to go back out.
Central there, that is Jenny.
They haven't gotten Maddie's phone yet, so this might not be the one where they get her phone.
First.
Okay.
The blue Corolla is Angelica's.
This one?
Yeah.
Okay.
And the silver Lincoln is mine. Well, it's actually my parents, but I'm driving the car right now. It's in better condition.
This is the one that she said she doesn't like to ride in?
Yeah, this is the one she was embarrassed to get dropped off in. So.
Okay.
Yeah, you're right. They asked to look inside, but I don't know that they didn't get a warrant and they were allowed to go inside. Now, they didn't necessarily go in locked boxes and locked rooms and things that I know of. So, I suppose that would be the difference. It's not until later when they get an actual search warrant that they probably go in the drawers and the closets and all the things. Take all the pictures.
I was that age. I understood.
I got you.
Forgive the donut there. I got a flat tire earlier this
That's
afternoon.
fine. You might want to put some and cover the firearm in there. Someone will steal that, man.
Oh, jeez. Yeah, I stuck it there when I was changing the tire.
I got you, yes.
Thank you for pointing that out.
A lot of people, they look in cars, if they see that, they'll smash that back window and
Yeah, I'm
take
not
it.
concealed carry, so
Yeah,
thank you.
good for you.
I appreciate it.
Are these all the cars?
I believe there's this Natalie car.
This one?
You know, he was nervous as Satan in a church house when they were looking at that car after he had known he had her body in there. Toby from The Office, that's funny.
Is that all of them?
Yeah.
Just those 4? Okay. All right, well, I'm going to go head over to Sisters. What is her name?
Stephanie.
Stephanie? All right, I'm going to go over there. What's a good phone number for you?
All right, so I was looking at this for the phone evidence, but it must be in an audio interview.
Okay. All right, I'm going to go head over there, okay?
Still good intel to review, though.
Do what?
I said it's still good intel to review.
Oh, yeah, absolutely. I'm going to we'll continue going over these documents and stuff tomorrow, and I'm going to work on finding the interview where they asked for Madeline's phone, and we're going to listen to that. I'll have to find it tonight.
So Bellis's question?
Does anyone think that Steppenstearns destroyed his tire himself at the dumping stop to hide what he was doing? That question has been posed in our chat before. Was the tire destroyed to make it look Oh, for his thumb. Because his thumb was smashed, and people were speculating that Madeline might have bitten him, and therefore he had a blood blister on his thumb. So he destroyed the tire himself so he could say that he smashed it in a jack. I don't think so.
I think he
But
rode that tire out a long time ago.
yeah, I think he rode the hell out of that tire. And uh got to where he was at before where he could place our body before he changed the tire, because he didn't want to be rolled up on with a deceased person in his vehicle and him changing the tire, because there is a possibility that the cops will roll up on you while you're changing your tire to see if you need help or whatever. I do think that there's no way in hell that he's impaired from TBI. How many years ago defense is going to stoop that low? Yeah. All right. Well, it is 5 o'clock. We have been going for 3.5 hours. I'm gonna have to go so that I can cook dinner, and we will continue this conversation tomorrow. I do believe it was an audio interview where they obtained her phone, so I will find that, and we'll continue going over these documents tomorrow.
It's been a pleasure. Thank you for having me up.
Yeah, thank you for coming up. I appreciate you hanging out today.
All right. Y'all have a good day. Everyone stay safe. God bless y'all.
You too. God bless you too. I love your picture, by the way. So pretty.
Well, thank you. We'll see you
Yeah.
soon, hon.
All right, love. Bye.
Bye-bye.
His dad couldn't figure out why the tire was in that condition. After all, it was Chris Stern's car, and he was familiar with his condition. Yeah, that's a good point. Yeah, thank you everybody for hanging out. I love y'all. I hope y'all all have a good night and a good day. Stay safe out there. Hug your loved ones. And if nobody has told you, you are important, you are special, you are loved. Thank you guys for the support and hanging out, and I'll see y'all tomorrow. Bye.